Good morning, everyone. Thank you all for joining us for the Board of Environmental Safety meeting. I am Sheena Brooks, the board's Operations and Outreach Manager and today's board clerk. Today, we are joined by the following Board of Environmental Safety staff: Swati Sharma, Executive Officer; Shana Avila, Staff Engineer; Lauren Chandler, Ombuds; Alicia Delphin, Administrative Liaison; Greg Forrest, Board Counsel; Rana G. Joshi, Environmental Scientist; Evelyn Nuno, Board Specialist; Linda Ocampo, Senior Staff Engineer; Firdos Permirza, Environmental Program Manager; and Marcus Raymond, Senior Environmental Scientist. This meeting is being live streamed and recorded. Your continued participation is acknowledgement that you are being recorded. Today is June 24, 2026 at 10:01 a.m. and the meeting is now called to order.
Thank you very much, Sheena. Please call the roll.
Thank you, Chair Rakestraw. Member Atkins. Member Brostrom.
Here.
Member Williams.
Here.
Vice Chair Strauss-Hacker.
Here.
Chair Rakestraw.
Here.
All members are present and a quorum is established. I will now review some logistical items. Today's hybrid meeting is being held both in person and remotely via phone and Zoom. For those joining us on Zoom, please select either English or Spanish as your preferred language option by clicking the interpretation icon located at the bottom of your Zoom toolbar. If you don't see the icon, you may need to update your Zoom application. If anyone experiences connectivity issues with Zoom, you can call in for either English or Spanish. The phone numbers are provided to you now on the slide. They will be provided in the Zoom chat, and they are also posted on our website. Agenda times may fluctuate to accommodate agenda items. Meeting materials are available on the registration table at the entrance of the meeting room. They can also be found on our website at bes.dtsc.ca.gov/next meeting. To protect everyone's virtual space and networks, the Q&A function will serve as our chat feature. It will be used for individuals that are experiencing technical difficulties or are unable to make verbal comments. If you wish to have your written Q&A comment read out loud during a public comment session, please begin your comment with "please read aloud." To ensure that all board members are fully present and focused on today's presentations and discussions, they are not reading or following along in the chat or Q&A. All participants will remain muted until a Zoom host unmutes them once recognized. Only presenters' videos or screens will be shared. We are looking forward to hearing from the public throughout the meeting and have scheduled times on the agenda to do so. And there are several different ways in which you can participate. For those joining us on Zoom, please raise your virtual hand on your Zoom toolbar or press *9 on your phone. I will call on participants using their name as displayed on Zoom, and I apologize in advance if I mispronounce any names. If you have joined the Spanish channel, please wait for the interpreters to provide instructions. To ensure our board members are able to hear comments from all members of the public who wish to comment today, we ask that you take no longer than 3 minutes to make a comment. And for those commenting in Spanish, time will be doubled to allow for translation. Agenda item number 3, the initial order on appeal for the Ecobat facility, is the first agenda item this morning following the board chair's opening remarks. We will be referring to a sign-up list to facilitate our in-person public comments for the initial order. So at this time, I would like to poll all of our participants to get an idea of how many folks plan to comment on agenda item number 3, the initial order. So for those in person, please raise your hand now if you plan to comment during the initial order item. And if you have not already signed up on the sign-up list, we do have a sign-up list at the registration table. Alicia can assist you. This is the order in which I will call on commenters to approach the podium. For those on Zoom, I'm taking a poll. If you all can please raise your virtual hands on Zoom so I can get an idea of how many folks on Zoom wish to comment for the initial order. I'm pausing to allow participants on Zoom to raise their hands at this time. I'm only seeing 2 hands raised on Zoom. All right, thank you, everyone. So again, for those in person, if you plan to comment on the initial order, please sign up so I can be sure to call on you. All right, our public forum for items not on the agenda will be heard today as agenda item number 5, which will be held at approximately 3:30 today. If you would like to express your comment in writing, you may submit your comment via email to besinfo@bes.dtsc.ca.gov. That concludes the introductory remarks for today's meeting. I will now hand it over to Chair Rakestraw for agenda item number 2.
Thank you very much, Sheena. Good morning and welcome to today's Board of Environmental Safety meeting. This board is a 5-member board created by Senate Bill 158 in 2021, which enacted fiscal and regulatory reforms to the Department of Toxic Substances Control to improve its transparency, accountability, and fiscal stability. The board members here represent the general public interest and act to protect public health and reduce risks of toxic exposure, with a particular focus on disproportionately burdened and vulnerable communities. We appreciate your participation here today as we work to achieving the goals and objectives set out for this board. So turning to today's agenda, it's composed of 3 main items. First, the board will consider the initial order for the Ecobat facility permit appeal. After that, our Executive Officer, Swati Sharma, will provide us with her Executive Officer report, which will include board business to review and consider for approval 2 board contracts. We'll hear board updates from our subcommittees and working groups, and we'll hear a permit appeal process presentation from our board counsel regarding standards for board member recusals. Executive Officer Sharma will also be joined by our board's ombuds, Lauren Chandler, to provide us with an action items update from our last meeting in April. The third item today we'll have on our agenda is public forum, as Sheena mentioned, for items that are not otherwise on the agenda, and this will be heard at 3:30 this afternoon. We're scheduled to end around 4:15 as well. So we'll turn to initial order for Ecobat, item number 3. So jumping right in 2021, SB 158 provided this board with the authority to hear and decide permit appeals for DTSC's permit decisions. Prior to SB 158, permit appeals were heard by a permit appeals officer located within DTSC. This board has spent significant time finalizing its regulations and standing orders for the administration of its appeals, and has heard 2 appeals fully to date, which were completed following the permit appeals rulemaking in 5 and 8 months, respectively. The board's role in hearing and deciding permit appeals is critically important. One of my priorities as board chair is to ensure that these permit appeals are fair, transparent, and timely in order to strengthen accountability and public trust in DTSC's permitting system. I do want to emphasize that the initial order for Ecobat's operating and post-closure permits, the issues being considered here today, are just that, an initial order. The substantive issues will be briefed between now and the hearing date. So for this morning, the order of operations for this agenda item will begin with the board staff presentation. Then each party will be granted 6 minutes for comments. We'll then open up the floor for public comments. At that point, we'll have a lunch break. Following that, we'll then have the board discussion and vote. So with that order, I'll now hand it over to Marcus Raymond, our senior environmental scientist, and our board counsel, Greg Forrest, to present the initial order for the Ecobat permit appeal. Over to you.
Thank you, Chair. As you indicated, I will provide the board presentation on the issue screen for acceptance or dismissal of the initial order for the appeal of the Ecobat permit decision. Following my discussion on the issues, the board's legal counsel will provide a presentation on the effect of the stay. Before I discuss the issues, however, I'm going to briefly provide the background on this appeals process. 9 total petitions were received for the 2025 permit decision, but 5 petitions were ultimately accepted. 3 petitions appealed the operation permit, and 2 appealed the post-closure permit. This appeal included 2 pro se appellants and 1 environmental group. Pro se appellants are appellants that are not represented by counsel. The pro se appellants file petitions for both the operation and post-closure permit. The environmental group, Clean Air Coalition of North Whittier and Avocado Heights, only appealed the operation permit. So this graphic displays the milestones in the permit appeals process. It essentially began in November of last year with the decision for the operation permit and post-closure permit, which was released by DTSC permitting. The notice of intent to file appeals were filed by parties in December of last year, and the petitions, which contained the statements of reasons, were filed in January of this year. The administrative record was finalized earlier this month with a ruling from the board's chair and vice chair on the motions to augment the record. So after today's initial order, some future dates to look forward to include the filing of opening briefs, which will support issues accepted for review, opposition briefs, and reply briefs, all of which will occur between August and November of this year. The appeals hearing is expected to be heard in January of next year, and then the final order is expected in February of next year. Okay, now I will discuss the initial order. So the initial order establishes which issues are accepted, the effect of the stay, the briefing schedule, and the hearing date. The initial order includes findings on the petitions that were submitted. The issues presented in the petitions were accepted if they met certain criteria. So pursuant to California Code of Regulations 66271.72, the petition shall demonstrate that all issues raised relate to matters that appears for the first time in the final permit or were previously raised in comments or testimony provided to DTSC during the public review of the draft permit, supported by citations to the administrative record, including the document name and page number. Board staff applied this standard when reviewing petitions. It was important for appellants to establish that the issue they raised was presented during the draft permit public review period with enough specificity to put DTSC permitting on notice of that particular issue. Merely identifying a particular topic area was not enough. Okay, now I will discuss the petitions for the operation permit. I will discuss the petitions in the order they were received. The first petition I will discuss came from pro se appellant Philip Chandler. Chandler presented a total of 11 issues for his operation permit appeal. Issue number 1 concerns the alleged deficiencies associated with the administrative record and is recommended for acceptance as a matter that appears for the first time in the final permit. Issue number 2 is proposed for acceptance on 2 grounds. The first of which on the argument that the final permit was missing an error monitoring and response program, which was raised during the public review period. And on the second ground, that the condition the appellant alleges should have been included in an error monitoring and response program, and the errorly deposited metal sampling work plan changed from the draft permit to the final permit, therefore is a matter that appears for the first time in the final permit. Issue number 3 concerns the compliance schedule in the final permit. This issue is accepted or proposed for acceptance on the basis that there were changes made to compliance elements the appellant contests should have been included in a compliance schedule. Therefore, this relates to a matter that appears for the first time in the final permit. Issue number 4 pertains to a regulated unit of the post-closure petition, the closed service impoundment, which was also contested in the appellant's post-closure petition. Therefore, it is addressed in the post-closure section of the initial order. Issue number 5 concerns the change in the permit term of the operation permit, which changed from 5 years to 10 years in the final permit. It is recommended for acceptance as a matter that appears for the first time. Issue number 6, similar to issue number 4, is related to the closed surface impoundment and is addressed in the post-closure section of the initial order. Issue number 7 concerns the alleged failure of DTSC to initiate permit denial proceedings. However, the appellant fails to reference public comments or testimony that demonstrate that this issue, the issue of permit denial proceedings or notices of deficiency was raised during the public comment period or public review period and is therefore recommended for dismissal. Issue number 8 concerns lead fingerprinting or lead attribution, which the appellant contests should have been included in an air monitoring and response program. So since this issue is closely related to issue number 2, it is recommended for acceptance. Issue numbers 9 and 10 concern surface water monitoring and yard sump RSA, respectively. However, are recommended for dismissal because the appellant failed to demonstrate that both issues were raised during the public review period. The appellant references many comments for issue number 9, but none clearly and specifically established how the draft permit failed to address surface water monitoring. The comment reference for issue number 10 does not mention yard sump RSA or the notion that eligible sumps should have been designated as hazardous waste management units in the final permit, and is therefore also recommended for dismissal. Issue number 11, similar to issue numbers 4 and 6, relate to a regulated unit of the post-closure permit and is addressed in the post-closure section of the initial order. So moving on to the next appellant, Clean Air Coalition. Clean Air Coalition raises a total of 7 issues. In their petition, Clean Air Coalition was able to demonstrate that issue numbers 2, 3, and 4 were raised during the public review period of the draft permit, and appropriately it accurately included citations to the final permit record. Issue number 1, concerning the alleged failure of the final permit decision to include findings of fact and conclusions of law to support the entire permit decision, is recommended for acceptance as a matter that appears for the first time in the final permit. Clean Air Coalition also demonstrated in their petition that issue numbers 5, 6, and 7 were raised during the public review period with citations to the final permit record and are all recommended for acceptance. Okay, moving on to the next appellant, Michael McKee. Pro se appellant Michael McKee raises a total of 5 issues in his operation permit appeal. The first issue concerns the deficiencies in the administrative record and is recommended for acceptance as a matter that appears for the first time. Issue number 2 concerns the unauthorized use of recycling tanks TK8 and TK11, which are located in the wastewater treatment plant. And issue number 3 concerns the alleged failure of permitting to initiate permit denial proceedings. The comment reference for issue number 2 came from the permittee, Ecobat, and was determined to be unrelated to the topic of the unauthorized use of tanks TK8 and TK11. The comment reference for issue number 3 made no mention of permit denial proceedings or notices of deficiency. Based on these facts, the reference comments for issues number 2 and number 3 failed to demonstrate that these issues were previously raised and are recommended for dismissal. Issue number 4, concerning an allegedly deficient human health risk assessment, was properly supported by public comments that indicate the issue was previously raised and is recommended for acceptance. Issue number 5 concerns the permit term and is also recommended for acceptance as a matter that arises for the first time with the issuance of the final permit. So to recap, board staff is recommending acceptance of issue numbers 1, 2, 3, 5, and 8 from Chandler, issue numbers 1, 4, and 5 from McKee, and all of issues proposed by or raised by Clean Air Coalition as it pertains to the operation permit appeal. Okay, now I'm transitioning to the post-closure permit petitions. And I will begin with pro se appellant Chandler. Pro se appellant Chandler presented a total of 5 issues for review, all of which are recommended for dismissal with the exception of issue number 1. Issue number 1 concerns the administrative record, and since the administrative record issue has been accepted in his operation permit appeal, and the operation permit and post-closure permit administrative record are one and the same, this issue is recommended for acceptance. Issue numbers 2 and 3 have been combined in the initial order since they both relate to stormwater capacity. These are the same issues that were included in the appellant's operation permit petition, but are addressed in the post-closure section of the initial order since they relate to a regulated unit of the post-closure permit. The appellant references a comment made by the permittee, Ecobat, which was a request to extend the storage period of stormwater on the closed surface impoundment during peak rainfall events, as evidence that issue numbers 2 and 3 were previously raised. This comment, however, does not clearly demonstrate that the appellant's contention that the inappropriate use of the closed surface impoundment to accommodate stormwater was a concern that DTSC was made aware of. As such, issue numbers 2 and 3 are recommended for dismissal. Issue numbers 4 and 5 are all recommended for dismissal as the appellant failed to meet the burden of showing that these issues were previously raised. Issue number 4 concerns the need for a surface water monitoring or soil pore liquid monitoring program that addresses constituents of concern in surface water that runs on the closed surface impoundment. The comments referenced by the appellant failed to prove that DTSC was made aware of the concern that a surface water monitoring program or soil pore liquid monitoring program was needed to address the potential for surface water with constituents of concern. The comments referenced for issue number 5 failed to clearly demonstrate that the issue concerning waste codes and slag was previously raised. In addition, the comment referenced for issue number 5 was unrelated to waste codes and slag. Based on the foregoing analysis, issue numbers 4 and 5 are recommended for dismissal. Moving on to the next appellant, pro se appellant McKee, who had contested the same issues in his post-closure petition that he did in his operation permit appeal. Issue number 1 relates to the administrative record and is recommended for acceptance as a matter that appears for the first time in the final permit. Issue numbers 2 and 3 are recommended for dismissal for the same reasons they were dismissed in the operation permit appeal, and issue numbers 4 and 5 relate to elements of the operation permit and were recommended for acceptance in the operation permit section of the initial order. So to recap, for the post-closure petitions, board staff is recommending to only accept issue number 1 from Chandler and issue number 1 from McKee. And that concludes my presentation. I'll turn it over to board counsel, who will discuss the stay of the permit, briefing schedule, and proposed hearing date.
Thank you, Marcus. As Marcus mentioned, one of the purposes of the initial order is for the board to determine the effect of the stay, and that's what I'm covering next. First, I want to explain what a stay is and how it works. A stay is a procedural pause on the effect of a permitting decision. The purpose of the stay is to maintain the status quo to preserve issues for appeal. The stay first applies automatically if an appeal is filed. Based on an analysis that I will cover, the board then determines the effect of the stay when it adopts the initial order. Once the stay is lifted, the permit takes effect. For background, the stay has been a feature of the permit appeal process since its inception. Historically, appeals were limited to conditions, but the board changed that by expanding the scope of permit appeals to include contested issues. That means that the board must decide how to characterize the issues in order to determine the effect of the stay. Because the stay maintains the status quo, the board must consider how the issues and conditions are related to changes to the status quo. Under our stay regulation, the board is required to limit the effect of the stay according to the issues that are accepted for review. Where issues contest particular conditions, the board determines whether the other conditions are intertwined with those contested conditions, and the board extends the stay to include the conditions that are contested along with others that cannot be severed. The board invited the parties in DTSC to submit briefs on this topic. The appellants proposed a full stay. This would have the effect of continuing the existing stay of the 2025 permit decision for the entire appeal process. Each of the appellants argued that their appeal challenged the permit decision itself and was not limited to individual conditions. This would mean that the facility would continue operating under its current permit. Any operational changes allowed by the new permit would remain stayed during the appeal. In response to the board's request for a briefing, DTSC proposed lifting the stay altogether. This would mean that all provisions of the new permit would take effect now. DTSC argued that the renewal permit should be allowed to take effect because the new permit provides greater community protections and oversight. The implications of this proposal would mean that the facility would implement changes to match new permit terms and conditions because the permit authorizes physical changes to the facility. In response to the board's request for briefing, Ecobat proposed a limited stay. Ecobat recognized that the appellants challenged certain conditions and conceded that those challenged conditions needed to be included in the effect of the stay. This would prevent Ecobat from making changes to the containment building and implementing other contested conditions. Ecobat's argument was that the board's stay regulation requires the board to limit the stay according to the issues that are accepted. This would affect the containment building improvements and a few other conditions, and I'll get into that. So staff recommends for this item a limited stay. Our recommendation is described in the draft initial order that was provided prior to the meeting and is based on our own legal research of the applicable law, our review of the briefs, our analysis of the renewal permit conditions, and our interpretation of the stay regulations. In particular, we focused on the changes in circumstances between the existing permit and the new permit. We found that the issues raised by the appellants only contested certain conditions. In total, we identified 15 conditions that are stayed. We found that all other conditions are severable. We rejected the contention that other broader issues required a full stay because of the particular circumstances of this renewal permit for this facility. The overall capacity of the facility is not increasing or expanding, so we did not feel that a full stay was justified. Instead, the limited stay that we propose prevents the facility renovations that could conflict with contested issues. However, the limited stay allows operational changes that do not conflict with contested issues. As I mentioned, we identified a total of 15 conditions that are included in the effect of the stay. These conditions affect the two areas of the facility where renovations are authorized by the renewal permit. The battery storage area is an outdoor area of the facility that will be repaved and improved with berms to contain spills. Because that condition is challenged by Philip Chandler's petition, that condition is included in the stay. I mentioned the containment building already. That is the other area of renovation at the facility. Because that was specifically challenged in the Clean Air Coalition petition, those 8 conditions are included in the stay. The Clean Air Coalition also challenged 2 conditions that apply to 10 different pieces of equipment inside the facility. The first condition requires Ecobat to cease its operation of that equipment if the ventilation system does not maintain a certain level of negative pressure. That condition is included in the stay and applies to 10 units. The other condition applies to the same 10 hazardous waste management units and requires Ecobat to perform weekly inspections of those units. That was also challenged by the Clean Air Coalition and is also included in the stay. While the stay of this condition remains in effect, a similar condition from the current permit will remain in effect. That condition requires weekly inspections of treatment process equipment. That condition will be carried forward with the new permit. The stay also includes facility-wide conditions from Part 5 of the new permit. Condition 3 requires Ecobat to notify DTSC in the event of an unplanned shutdown of any emissions control device. This is a new requirement. Condition 5 requires Ecobat to sample and test feedstock into the reverberatory furnace. That is also a new requirement. Condition 6 establishes a list of materials that are allowed to be processed in the reverberatory furnace and prohibits other materials from being processed. While condition 6 is stayed, a similar condition from the existing permit will remain in effect. That condition limits rubber and plastic from being processed in the reverberatory furnace. That condition will also be carried forward with the new permit while the stay remains in effect. Condition 19 is a new requirement for Ecobat to maintain a public website and post air sampling results. That is being challenged by the Clean Air Coalition as included in the stay. Okay, so just to recap, we are recommending a limited stay of only 15 conditions. In all other respects, the renewal permit would take effect. Included within the stay are 2 facility renovations, the containment building and the battery storage area. While the stay is in effect, 2 conditions from the current permit would be carried forward as placeholders for the 2 stayed conditions that I mentioned. In all other respects, the current permit would be superseded by the new permit. Lastly, because none of the issues that were accepted for the post-closure permit relate to any conditions of the permit, there will be no stay of the post-closure permit under our recommendation. The initial order also establishes a briefing schedule. Opening briefs are due 60 days from the issuance of this initial order. Opposition briefs are due 45 days after the opening briefs are filed, and reply briefs are due 30 days after opposition briefs. The appeals will be heard jointly at a public hearing at a location and time to be determined in the Los Angeles area. We have tentatively proposed a date of January 27, 28th, 2027 for the public hearing. However, we have received a request for this date to be moved to later in the next year, and we're still looking for an appropriate venue. It is quite challenging to find a venue. This venue is not going to work. It's too small. We're already pressing the limits of this venue right now, it turns out. So we asked to insert language in the initial order authorizing the executive officer to finalize this hearing date after this meeting today. Right, so just to conclude then, we maintain a running docket for the appeals on our website where we post briefs, correspondence, and other information regarding the appeals. Our website address and email are listed on this slide. I want to give special thanks here to Marcus Raymond, Swati Sharma, and Sheena Brooks, and all the other members of our board staff who put in the hard work to get us to this point. That concludes my presentation.
Thank you very much, Marcus.
Chair Rickshaw, if I may. Quick announcement, we're so pleased to see so many people turn out today for today's meeting in person. As everyone can see, we have met our capacity for the meeting room. So it is a hybrid meeting. We encourage folks to participate and tune in on Zoom. Or you can stand by outside until space does open. But just wanted to make that announcement real quickly.
Thanks, Sheena. So thank you very much, Marcus, Greg, and the technical team for their work on this draft here. So at this point, we'll now turn to the parties to provide comments up to 6 minutes. So we will first start with Council for the Clean Air Coalition. We'll then go to thanks, Sheena. Philip Chandler. So thank you very much, Marcus, Greg, and the technical team for their work on this draft here. So at this point, we'll now turn to the parties to provide comments up to 6 minutes. So we will first start with
It's a new system, everyone. Pardon us.
I hate hearing myself recorded. Okay, and then we'll go to DTSC, followed last by Ecobat. So now I'd like to invite up Council for the Clean Air Coalition. Please join us at the podium. You have 6 minutes. Thank you.
1 second. Can you hear me?
I could scream, but presumably that's inappropriate. Can you hear me now? No? Can you hear me now? Angela Johnson-Mazzaros on behalf of the Clean Air Coalition of North Whittier and Avocado Heights. The board proposes to accept all the issues CAC raised in its petition. This is the correct outcome for that decision. However, the proposed order's decisions regarding the scope of the stay, the exhaustion of issues raised in the motion to dismiss, along with the prior decision on the administrative record in which the full board has declined to participate, are not correct. 6 minutes? All right, we'll focus on the scope of the stay. It is quite unsettling that the proposed order clearly embraces the challenged assertion that Ecobat's permit should be renewed. In fact, after permitting considered its decision for more than 10 years, the board intends to renew the permit today. Before the board reads one word of briefing on the issues, hears 1 second of argument on the merits, listens to one community member, or spends even 1 moment deliberating the facts, policy, and law at issue in this review process. The board is challenged with providing an impartial review of permitting's decision. Yet this order strongly suggests that the board does not believe the issues raised by petitioners are as critically as important as we know they are. As a matter of fact, the board proposes to find that, quote, most of the issues advanced by CAC are matters of procedure that do not justify a full stay of the renewal permit. Justify. To whom? The board claims that while it, quote, broadened the scope of the appellants may challenge in the petition, it did not make a corresponding change to what must be stayed while the challenge is pending. In other words, the board feigned openness to hearing challenges, but refused to commit to providing relief based on those challenges. It's a dastardly plot, indeed. At the behest of Ecobat, the board ignores the fact that procedure and substance, often as here, cannot be separated. Think, for example, of voting, seeking asylum, assessing healthcare, or a number of issues for which procedure can determine the outcome, or at the very least, stack the deck against those most vulnerable to abuses of power that it becomes practically impossible to protect oneself, family, loved ones, or community. We urge the board to think long and hard before it decides that government actors can skirt procedure, and that does not provide a basis for relief. At issue here today is the procedure the board will follow for the decision before it. When interpreting a regulation, the plain language always controls. It's a way to curtail a possible impulse to change what the law means in order to fit a desired outcome. Here, the language of the regulation could not be more plain and could not be more clear. A permit decision is stayed until either dismissal of a petition in full or denial of a petition on the merits, unless only specific conditions are challenged and that no way implicate others. So today, the portion of the regulation that addresses what to do when a petition challenges only specific conditions isn't relevant. The proposed order does not acknowledge the full regulatory language at all. Look at page 32. Instead, it ignores the plain language to construct an elaborate story about conditions and provisions and issues to justify approving the permit today. The board proposes to, quote, determine that maintaining a full stay of the renewal permit decision is in its entirety is unwarranted. Unwarranted. Indeed, the board proposes to find that, quote, CAC's mere allegation of error unrelated to conditions does not justify a full stay. It's really breathtaking. CAC's allegations, first, all of the parties' statements are allegations. The time to prove allegations comes next. Second, CAC alleges procedural error. It also alleges that permitting unlawfully processed Ecobat's application developed conditions that are not protective, took an unsupportable, weak-willed approach to Ecobat's flouting of laws meant to protect health and the environment, and has contorted policy in a way that breaks trust with frontline communities demanding protections to which they are entitled as a matter of law and as a matter of justice. Third, and most striking, is that the board accepts permitting and Ecobat's allegations as proof. stating that, quote, DTSC and permitting show that the general public interest favors allowing the renewal permit to take effect. This is improper. A showing requires evidence, and none has been presented by the parties. There could not be because that part of the proceedings has not happened yet. In fact, the protectiveness of the permit's condition, both individually and collectively, is the exact issue that CAC challenges here. The board proposes to remove the stay for all but a small handful of conditions because it's so protective. This is neither the time nor the place for the board to decide that the permit is protective, and to do so now would be unwarranted. The board calls today's decision procedurally lifting the stay. It's actually approving the permit, and it's unlawful. For these reasons and so many others, CAC requests that this board accept all of the issues presented by its petition and maintain the stay for the entire permit as required for law. Obviously, given the limited time that the board has given me, it's impossible to address all of our concerns, but please don't hesitate to ask questions based on your review of our briefing. Thank you.
Thank you very much, Council. So we'll now turn to Philip Chandler, one of the pro se appellants for Ecobat's operating and post-closure permits. Mr. Chandler, will you please join us online? Please, Gina.
Mr. Chandler, we are setting you up as co-host, so you will be able to unmute yourself and share your camera if you like. Just give us 1 second. Mr. Chandler, you are set up as co-host. Please feel free to unmute yourself and or share your camera if you like. You have 6 minutes.
Am I unmuted now?
We can hear you.
Okay, you can hear me. Good enough. My name is Phil Chandler. I used to work for DTSC. I was responsible for closing the surface impoundment that's now being used to support operations. I was also responsible for groundwater monitoring response issues. In 1996, we did a CME. Those issues have finally, after some 20-odd years, been quasi-resolved. I was responsible for issuing the permit in 2005. I was responsible for taking a look at lead depositions outside the facility, once in 2004, and then again when somebody handed me the damn job again in 2012. That's the reason for the air monitoring response plan issues. Now, my concern is a lot of the issues that were dropped, my issues that were dropped. And of them, since I only have about 6 minutes, of them, perhaps the most concerning is my appeal 10, which is the board's issue 4. You indicate in your decision that it's something that deals with the post-closure permit. Unfortunately, the permittee and DTSC seem to believe that the closed surface impoundment, this closed unit, can be used to support secondary containment of the operational wastewater treatment plant. Okay, now that's an operation. That's not a post-closure plant. So there is an issue of that usage, which belies the decision. The matter, and matter is this is an issue that we have an issue, a matter issue definition. But the point is that the element that was raised here is applicable to the operation permit. It's crossover issue. It was raised also by asking, by looking at the comment provided by the permittee. And one of the things the permittee admits in the comment, and it's a quote from 66264-228, and I forget the rest of it. Any pounding of stormwater or surface run-on the concrete caps of the regulated units is prohibited. They add something new to this. They say, well, the regulations say it, but we're going to use 1 inch of ponding as being acceptable. And so on. They go into a number of issues, a number of elements that are talking about how much rainfall, da, 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 da. All of this goes to the inability of the current wastewater treatment system, secondary containment. It can't contain what it's supposed to contain by regulation. The same thing is true of the battery storage area, which they've accepted some element of concern on. The battery storage area is a very low-lying area. It sits with about a 6-inch berm. You're looking at it from a satellite image. It actually overflows at the low end, looking at the topography of it, which is provided in the Part B application. It drains to an end, the low end, which overflows. There's no sump there. Where it overflows, and it goes downslope and gets caught up by the RSA sump, which is now not an accepted element of this this appeal. That means that the hazardous waste constituents, reaction products, now there are those things that burn up and wind up on the surface, those things all flow down to that sump, which in the 2005 permit is a regulated unit. In the 2025 permit, it disappears. It's not closed. Department didn't bother to try to close it. That would have required notice to the public and a permit modification. Oh, heaven forbid we should do that. So that unit now vanishes, along with another sump that was part of the of that permit, the YS1 sump, over on a former, well, actually waste piles, but they're euphemistically termed former raw material storage area. So those things now vanish. No permit mod. They are used, okay, in the operations. The PHMSA is used because the wet electrostatic precipitator is sitting right on top of the unit. I can't find any evidence that there was ever any formal approval of that. Same thing with soda ash units. So they're used, both used in operations. So clearly, I can go on to the other elements, don't have the time, but clearly for Appeal 10, this decision is wrong. It's an operation unit issue. Yes, it's using a closed surface impoundment. Using the closed surface impoundment. Using it as a hazardous waste management unit because you park trucks on it. In fact, it's termed in the permit the incoming liquid waste staging area. Liquid waste, battery acid. Okay, so this is a problem. So I have a problem with each of the decisions there. My 6 minutes is up. If you have questions, ultimately, fine. If not, thank you.
Thank you, Mr. Chandler.
Thank you very much, Mr. Chandler. So we'll now call on Michael McKee and Duncan McKee. Michael McKee is participating remotely, and Duncan McKee is here in person. They're splitting their 6 minutes. So
Michael go first.
Michael will go first, and then we'll turn to you.
Thank you.
Please.
Mr. McKee, you have been given co-host abilities. Please feel free to unmute yourself and share your video if you like. You have 3 minutes. Mr. McKee? Mr. McKee, are you able to unmute yourself? I've sent you a request to unmute.
Sure, I can go.
Okay, let me let him know. Mr. McKee, we will have,
He's elderly,
okay,
according to Mac.
okay. Michael, we will let Duncan go. Oh, okay, I see you.
Okay.
Perfect.
Okay, am I working now?
Loud and clear, thank you. Michael, you may go ahead.
Okay, well, our family lives in Avocado Heights in a heritage home that we've lived in for 80 years. We believe that numerous toxic substances emitted by Ecobat were a contributing factor to the deaths of an unusual number of people in our small community at 12,000. As an example, the U.S. National Cancer Institute states that exposure to 1,3-butyldiene increases incidence of leukemia and other cancers, including carcinoid. Our mother died of this rare carcinoid cancer, which affects 1 in 100,000 people. Our next door neighbor also died of the same cancer. And again, a community of 12,000. Here are 2 people already with carcinoid. Our father died of leukemia. Our brother David died an agonizing death from leukemia and bowel cancer. Our friend Al Braga lived at ground zero. He died of liver cancer. David Bragg and Lillian Avery died from leukemia. Willie Bazzuti died from pancreatic cancer. SCAQMD and DTSC heard similar documented reports from fellow community members February 9th, 2022, in other public meetings. Common sense tells us that toxic chemicals and metal discharge into the community need to be stopped. The facility is 68 years old, and despite upgrades, it continues to pollute. A plan should be developed to decommission the facility and move it to a safer location, and then build a state-of-the-art facility in a better location. Thank you. I'll leave the rest of the time for Duncan.
Okay, so you want me to go or?
Yes. You may go ahead.
So, all,
Is your microphone on? There you go. Pull it closer to you. Yeah, speaking
Sure.
to the microphone. Thank you.
so our position is all the conditions and both permits in their entirety should be stayed. And DTSC must be required to pull back the permits and correct the numerous errors that are contained in the so-called final permits. This is in the best interest of DTSC, Ecobat, and the public. Keep in mind they continue to operate, so they're not losing money off it. Okay, there are a multitude of reasons why this is the logical best option. The matter of the health risk assessment has numerous issues that must be resolved. And the most recent health risk assessment to quantify the true comprehensive current risk with the facility needs to be utilized. Presently, DTSC and South Coast do not take into account people like myself and my family and my community members who have lived here for an extended period of time that were exposed to even greater risk than the current risk. They're only moving forward like it's a new facility. It's wrong. Okay, the people who have lived here for a long time have a much greater risk of developing these health ailments from this facility. DTSC used a 2014 health risk assessment when the 2016 health risk assessment from South Coast shows a 16 in a million cancer risk. So why are they using the 2014 that shows less than 10? Okay, there's missing data. There's arsine. There's gaseous forms of chromium. There's stibine. There's a lot of things the data is missing from the health risk assessment that are not being taken into account. The wet scrubbers are scrubbing volatile organic compounds and other substances out of the air. They're conveying it to the wastewater treatment facility, which are open tanks. There's material volatilizing. There's no source testing from South Coast. The data is missing from the health risk assessment. Until we get a handle on this, the entire permit should be stayed. And again, it's to the benefit of DTSC and Ecobat. Okay, how are you going to deal with like missing hazardous waste management units? There's at least 10 or more permit modifications. There's potential violations. There's a lot of things that will result if you go ahead and do not stay this entire permit. It's going to be way more drawn out and complicated to deal with the violations, the permit modifications.
Please wrap up your comment.
So that's a total of 6 minutes?
3.
We can grant 1 extra minute. Thanks.
Okay, and the analysis of the material going in is completely inadequate. You're not taking into account the PVC, the different types of plastic, the plasticizers, the UV inhibitors, the things that are contained in that plastic, and the COCs, the constituents of concern that are a result of it being incinerated. And you're allowing them, as long as they don't separate the plastic and rubber, you're allowing them to burn it in the refurb. You don't even say anything about the electric arc furnace or the material that's going into the kettles. There's big problems that need to be resolved before you allow this to move forward. And again, it's in the best interest of everyone to do so. Thank you for your time.
Thank you very much, Duncan McKee and Michael McKee. So we're now turned to DTSC, I believe Division Chief Wayne Lawrenson will represent DTSC. Please join us at the podium, and you'll also have 6 minutes.
Good morning, Chair Rakestraw, members of the board. My name is Wayne Lawrenson. I manage the permitting division at DTSC. And I want to thank you for managing this aspect of the appeals process. We're very pleased that the board chose to lift some of the stays on some of the conditions and allow some of the protections that the permit offers to go into place. Our permit has over 100 conditions. All of them are meant to protect public health and the environment. So I want to use my 6 minutes to focus on 4 items that we just want you to be aware of, to share our perspective about what the effect of the stay means on 4 of these conditions. The first one being special condition 2 of all those units, 2, 8, 9, 14. That stay essentially means that Ecobat will not be required to cease adding hazardous waste to those units during times when the ventilation in the enclosed furnace area rises above the set negative pressure of 0.02 millimeters of mercury. So when the negative pressure is lost, all of those units, Ecobat will be allowed to operate all of those units. The requirement to cease activity of those units goes away with the stay of those conditions. We just want you to be aware of that. The second one being condition 4 of unit 20. And I understand the board's rationale in issuing the stay for all of the conditions in the containment building because of the construction needed for the building. But condition 4, staying that condition means that Ecobat will not be prohibited from placing hazardous waste in piles that exceed the height of the crowd walls. Those crowd walls are already in place now. That's a protective condition that we just want you to be aware of. It doesn't have any effect on the new containment building. The next one being special condition 3. Staying that special condition 3 in section 5 means that Ecobat will not be required to notify DTSC within 1 hour of an unplanned shutdown of any emission control device. They will also not be required to send DTSC air sampling data and an explanation for why the shutdown occurred. And we think that that's important for your consideration in the vote. The last one being special condition 13. The board stay of that special condition means that Ecobat will not be required to provide any air sampling results from the fence line monitors or the stack monitor that's sampled daily on their website. And I know that's a new condition, and it's tied to the fact that there's this community air monitoring system that's all conditioned, that's also stayed. But we just want you to be aware that unintentionally that may, a website could be created for the community to display all of that data, and that would not happen if the stay for that condition were to stay in place, if that makes sense. And for the rest of my time, I'd like to turn it over to Ryan Choi for our council to talk about schedule. Thank you.
Good morning, honorable board members. My name is Hangwon Ryan Choi. I'm a senior staff counsel with the DTSC Office of Legal Counsel representing the Permitting Division. I'm here today to respectfully request a 15-day extension of time for DTSC to submit its response briefs. Currently, the draft initial order allows 45 days for the response briefs. However, DTSC will be dealing with 3 distinct opening briefs, each involving complex permitting issues. Reviewing all 3 briefs thoroughly and preparing meaningful, comprehensive responses within the 45-day window will not be feasible. Therefore, given the number of appellants and the size and complexity of these pending appeals, DTSC Permitting respectfully requests an additional 15 days. Importantly, accommodating this extra time will not disrupt the board's schedule. Thank you for your time and consideration.
Thank you very much, DTSC. So we'll now turn to council for the Ecobat facility. I believe Matt Williamson will be joining us here today. Please join us at the podium, and you also have 6 minutes.
Thank you, board members. I have the distinct pleasure of going last, getting to address everything that everybody said, but appreciating I only have 6 minutes and we have a very lengthy and thoughtful draft initial order. I'm going to touch a number of topics at a high level. I wanted to start off with the comments by DTSC about the stayed conditions and some concerns from DTSC on the stayed conditions. Frankly, most of the concerns that DTSC raised, we actually already comply with those, either with the negative pressure requirements. Most of those are already in our AQMB permit. Pile heights is in our existing permit. To the extent there are any concerns about stayed conditions creating compliance issues, Ecobat is happy with any of those concerns that DTSC raised to voluntarily comply with them, or even put something into a legally binding document to say that we will comply with them, just to take that issue off the table. We don't want to be in a position where, given the way that the regulations are written and the stays are created, we have any potential compliance holes. And so we just want to put that out right off the front. There clearly isn't enough time to go through each of the legal conclusions and factual findings in the initial order. So I want to touch on a couple. We largely agree with the legal analysis that is contained in the draft initial order by board staff on both the stay framework as well as the exhaustion framework. So I won't go into that in detail. We do have some disagreement on the actual application of those standards to particular conditions and issues that were raised. That said, having reviewed them, we are happy to submit on the way that the board or the board staff has proposed in the initial order, and accept the way that they have formulated both the stay and the acceptance of issues. Those are disagreements that Ecobat doesn't feel need to be fought at this time, so we'll accept the board's formulation in the draft initial order. I do want to touch on the stay in a bit more detail. One of the things that we heard from CAC is that the plain language of the regulation requires a stay of the entire permit. Without going into too much details, there are 2 sections to the relevant regulation. There's an A and a B. A was the language we heard from CAC. B then contains a whole slew of limiting language. It is very clear that in formulating a stay, the board is to limit that stay and only apply that stay to the issues that are being raised in the petitions, and apply that to the conditions in the permit. we can't just skip over that, and there are very important reasons why that is the case. I could take the draft initial order's exact language, in fact, where the initial order says a limited stay will enable measures that have not clearly been contested by the appellants and that appear to be protective take effect, which better aligns with the board's mandate to further the public interest, protect public health, reduce risk of toxic exposure. That is exactly what is happening here. As we heard from DTSC, this permit contains a slew of conditions that improve the environmental operations of Ecobat City of Industry facility. So applying a blanket stay prohibits Ecobat from implementing many of those conditions. This is not a case, as opposed to where I started, where we could voluntarily comply with some of these. These are facility improvements or process improvements that require authorization from DTSC permitting in order for us to implement them. So it is important that we're able to limit the scope of the stay to the specific issues that are being raised in these appeals in order, again, to preserve the appeal rights of the petitioners, while on the other hand, allowing for these projects to go forward that have a real public benefit. And we heard from CAC that it was improper for the draft initial order to conclude that there was a public benefit. There were many rounds of briefing. It was very clear from that briefing that both DTSC and Ecobat were representing that these projects had a clear benefit, and we heard no opposition from any of the petitioners. So that opportunity has passed. We still didn't hear from the comments what specific environmental harm will ensue from allowing these, again, uncontested conditions in the new permit that allow Ecobat to implement some real environmental improvement projects. We haven't heard and still haven't heard what the potential harm is from those. So again, I think there was a great balancing and a very thoughtful analysis that was done in the draft initial order that allows Ecobat to go ahead and implement projects that have a real benefit. And something that board staff talked about this briefly, and I recognize you only have 50 seconds. It's also important to remember this is a different permit, and this is a different outcome than what we've had in some of the other decisions with stays. This is not a case where we have huge projects being implemented at Ecobat, huge construction projects. These are process driven. These are small changes. So it essentially is the same facility, just being able to make some tweaks here and there that have some real benefits. So again, we don't have that justification and that concern of that there's going to be an entire change to the facility that will somehow undermine the appeal process. So I'll just conclude with, I thought it was a very thoughtful analysis that reaches the right outcome and it allows for environmental improvement projects to go forward. And so I'd urge the board to adopt the draft initial order as a final with a limited stay. Thank you.
Thank you very much, Council. So thank you to all the parties for their 6 minutes of comments. So next we will open the floor to receive public comments on this item. I want to remind everyone again that we are only considering the initial order today, and we will be holding a full public hearing on the appeal in the beginning of next year. So Sheena, will you please lead us through the public comments?
Thank you, Chair Rakestraw. The floor is now open for public comments on agenda item number 3, the initial order. For those that are joining us in person and wish to comment on this item, if you have not yet already added your name to the sign-up list, please raise your hand now, and Evelyn will go around and make sure that you are on the list, because I want to make sure that we hear you out. So Evelyn, we're going to use the sign-up list for the facilitation of this item. Please raise your hand if you have not yet signed up. I'm going to call on the first 5 people. This is the order that we are going to hear comments. And if you anticipate that your comment will be longer than 3 minutes, please submit your comment to us in writing at besinfo@bes.dtsc.ca.gov to be included in the record. I will start with our in-person participants. So starting with the first 5, I'm going to call out your first names. Number 1 is Rebecca. Number 2, I apologize if I mispronounce any names. It looks like a Maryland or Norwegian. Last name Kamimura. 3, Jenny Knack. And 4, Jaime Sanchez. I think that's a good number to start with for now. But again, if you have not yet added your name to the list, please raise your hand so that we can hear your comment today. Okay. See, right. Rebecca, you may go ahead.
Thank you. Good morning. My name is Rebecca Overmeyer Velasquez, and I am the coordinator of the Clean Air Coalition of North Whittier and Avocado Heights. The BES is not a court. You are not part of the judicial branch of government. You are part of an agency of the executive branch embedded in that agency deliberately to provide the public visibility into agency decision-making as part of your oversight of DTSC and DTSC's leadership. Because the DTSC's decisions, like its approval of Ecobat's permit, have had a significant and often negative impact on overburdened communities like ours, the legislature created the BES to give communities the opportunity to represent our concerns to you, so that you could hear directly from us about how the agency impacts our lives. And all these folks are here also to tell you that. And by hearing us, the hope is that you will take our experiences seriously and consider them in your decision making. That's why we're here today. We read your argument opposing Clean Air Coalition's request for more public documents to be added to the administrative record for our appeal of Ecobat's permit renewal. These are documents in the public record that provide important context for permitting staff's decision to renew the operating permit for a facility with a long and checkered history of permit violations documented by a variety of regulatory agencies, a facility that even DTSC admits has left a toxic lead legacy in our neighborhoods, a legacy that is completely ignored in the permit's human health risk assessment that Katie Butler herself acknowledges incomplete. These are just two of the issues we have raised about the Ecobat permit that should have been fatal to its renewal. What information did staff use as the basis to approve the permit despite these and other problems? Why are so many documents in the proposed administrative record redacted without justification? All we have asked for are attachments to documents included in the record, earlier versions of documents along with responsive comments from or to permitting related to those documents, documents directly referred to by other documents included in the record, documents that were in permitting's possession or held by other offices, and documents named in the index that are missing. Given the BES stated charge to, quote, represent the general public interest, protect public health, and reduce risks of toxic exposure with a particular focus on disproportionately burdened and vulnerable communities. We heard you say that today, Andrew, unquote. We expect to have these documents released to us, the public. Remarkably, instead of agreeing with us and furthering the public interest, your argument echoes the same language and even cites to the same sources as the arguments that Ecobat and permitting have made opposing our request. All three documents are virtually interchangeable. The BES is supposed to be neutral and fair to all parties, but your decision against CAC calls this supposition into question. This is a serious problem. The public's due process rights are at stake, and we expect the BES to consider how the board made this decision. And one more thing, process matters. Stay the entire permit. Thank you.
Thank you for your comment. Second person, Kamimura. I apologize if I mispronounced that.
Good afternoon, good morning. I'm Marilyn Kamimura, and I'm part of Clean Air Coalition. I have worked at Ecobat for 12 years. I live in Avocado Heights in North Whittier, the vulnerable community. I would like all those I'm speaking for to please stand up. Okay. We have come here because we want you to accept our appeal in its entirety and keep the stay and keep this in this whole process, that the stay be in place until everything is settled. I have young children and grandchildren. We tested my soil over the rafters at, it shouldn't be over 80, it was 250. As a result of it, I removed my whole patio because of the fear for my grandchildren. I cemented my backyard. I have lived in North Whittier, Avocado Heights for over 55 years. With that, it comes fear. And this is what I want to bring up. This whole process of Ecobat has created fear. I don't think as an environmental justice community that we are surrounded by the city of industry, that we are to have that fear. What is happening now in this whole society of Southern California is fear. And we are saying, stay this permit. Ecobat, in my belief, has always been they should be moved. Thank you.
Thank you. Shani Nak.
I am Jenny Knack, Parents Against Santa Susana Field Lab. I'm here to support the Clean Air Coalition's request for a stay on the entire Ecobat permit during the appeal process, and Passable echoes the request for a permit denial. My particular concern with this issue is the refusal of existing documents currently a part of the public record to be included in the administrative record. It's well known amongst frontline communities from all over the state that the attachments and appendices are often where the issues lie with DTSC. I've said it before you many times, the devil is in the details. And here we see the issue before us again. DTSC permitting would like to keep the discussion off the information being requested for inclusion, and by allowing DTSC to restrict the contents of the administrative record, keeping the contents of publicly available documents from the table. You restrict the community from being able to make their full case, and it puts the legitimacy of the hearing, I think, in question. If you don't allow the information that impacted communities deemed salient and imperative to your understanding and the evaluation of the permit to even be considered, we're doing the community a disservice and frankly limiting the breadth of your perspective on the issue at DTSC's request. Frankly, anytime DTSC attempts to restrict something from your view, I think all of us in this room would beg you to insist on taking a very close look at the contents of it. Frontline communities routinely see the omission, denial, and obfuscation of important information by DTSC as one of the ways in which their failures are executed and hidden. Changing this practice and allowing the requested documents in the administrative record so that a legitimate hearing on the merits can take place is my request. Thank you.
Thank you. The next 4 commenters will be, no need to line up at the podium, but just be prepared. Next one is Jaime Sanchez, followed by Vivian Zamora, Maria, I apologize, I can't read your last name, and then Mark Hoffman. Jaime, you may go ahead.
Yes, before we begin, I was informed by staff that I would have 6 minutes to comment. In the event that that is not correct, I'd like to request 1 extra minute.
Yeah, you can have 1 extra minute, please.
Thank you.
Thank you.
1 second, Jaime.
Good morning, members of the board and staff. My name is Jaime Sanchez. I am a resident of Los Nietos and a member of Neighbors Against Fibertech. We are here to support the appeal submitted by the Clean Air Coalition. We ask you to stress test every element of the permit renewal and observe for yourselves every weakness, every failure by DTSC to comply with policy, procedures, and statutory authority. Why? Because here's what is at stake. If DTSC can act with impunity, that is, command decisions that only benefit the toxic substances industry by claiming full compliance and economic necessity, then there is no protection for the public, communities, and the environment. In such a case, checks and balances just don't bend, they break. Public participation, administrative procedure, due process, etc., all become a fallacy and thus irrelevant, and so does the role of BES. What am I afraid of? Not DTSC, because the environmental justice community has demonstrated the will to stand up to their malfeasance. What I am afraid of is that BES will lack the courage to defend the principles on which it is based, that it will lack the strength and leadership to see through DTSC's feigned compliance with the issuance of this permit for what it truly is, an abuse of discretion, that it will fail to perceive with clarity that this thinly veiled hypocrisy is simply another example of DTSC's intentional effort to circumvent and disregard essential and fundamental elements mandated by law. Predictability is just consistency made visible. In the case of DTSC, it is a curse that the public must bear. In the case of BES, it can become an approbation of propriety, of integrity. We, the public, and you, BES, have an opportunity to defend the people of the state of California. Let us do it together in recognition that the health, safety, and welfare of the public and the environment are worth protecting at any cost, including the influence of special interests. Please forgive me, for my harsh words of criticism are not intended to offend. They are intended to demonstrate genuine concern of a crisis that exists in our communities and that only BES can resolve justly. Therefore, we ask BES to grant the appeal by the Clean Air Coalition in its entirety and maintain the stay pending the outcome of the proceedings. Thank you.
Thank you. Next one is Vivian.
Good morning. My name is Vivian Zamorano. I'm a volunteer with the Clean Air Coalition. And I know you've heard this several times this morning, but I think it bears repeating. DTSC is supposed to protect people, communities, and the environment from toxic substances. And you, the board, are supposed to represent the public, me, us, particularly those of us in disproportionately burdened communities. You're supposed to make sure DTSC protects our health through reforms and transparency. With that focus, Ecobat's permit should not have been approved. It should have been denied. The poor procedures DTS has in place, or rather still doesn't have in place, keep my community in danger from exposure to toxins. How can a permit be granted without truly meaningful measurements, denial criteria, and transparent administrative records? At minimum, BES must ensure DTSC provides all documentation so that BES can make an informed decision and CAC can prepare a comprehensive appeal. Historically, we know industry tries to deny culpability and fight strong government regulation. The City of Industry and Ecobat are no exception. But people's health should be more important than claims of economic need, or rather greed. Conmeco should not be allowed to pollute 400 feet from people's homes. Environmental protections would only occur if government leaders and community activists have the courage to fight for change and for what's right. The BES and DTSC can solve some of the problems and prevent future catastrophes that we are seeing now in overburdened communities. Reform the decades of poorly regulated industry in cities like Commerce, which was incorporated when in, 1960, Industry, 1957, Santa Fe Springs, 1957, Vernon, 1905. These communities have had the burden of these pollutants. Be courageous and push for new meaningful standards to protect people and not allow toxic polluters to operate next to residential neighborhoods. Be brave, change the course of environmental regulation, make Ecobat a precedent for change, deny the permit. Thank you.
Thank you. Real quick announcement. Since we have reached capacity, we do have a handful of folks that are on standby in the lobby. So if we can get volunteers that maybe after you're done commenting, maybe switch out with them. They would also like to comment. So we would like to hear their comments as well, but would appreciate if we have volunteers that would like to swap out with those folks as well. Okay, moving on to the next one. Maria, I think it's Thorpe.
Good morning, honorable members of the board, our respected community, and our hardworking Ecobat staff. We welcome this meeting. I'd like to start to say that we have Valentina here. She's 9 months old, and my grandson Randy. I always have to acknowledge him, or he'll start yelling. We teach our children to connect the dots, to look at the big picture in the long run. What is best for our community? What is best for humanity? I'm a member of the Ritzavika tribal nation. We're stewards of the land, and we respect each other. As an arm of the Environmental Protection Agency, it's your duty to embrace the community, to embrace our workers, to protect all of us. We're all part of one humanity. And it's so important that we survive and live in health and happiness. My grandfather worked for the Workmen Roland families in now City of Industry. It wasn't City of Industry then. He died at 108 years old. No dementia, no disease. His heart peacefully stopped. Isn't that a beautiful way to die? We took care of each other back then. We all took care of each other. We cared. My father, my precious father, worked as an engineer for Gould National Battery there in, I believe it's La Puente, off of Nelson Avenue and 7th, near what was then Comeco. And we lived sandwiched between Gould National Battery and Comeco, that is now Ecobat. It has expanded substantially since we've been there, substantially. It has polluted substantially. I'm sure you're aware of the constituents that we've been exposed to. And there isn't a member here that hasn't suffered cancer, leukemia, thyroid issues, pancreatic issues. We're human, we have frailties. Whatever the pollutants cause in our separate conditions because of our separate frailties still impacts us. My father died, my precious father died of cancer, and we miss him dearly, and we need him, but we don't have him anymore. We want to keep our community intact. We want to keep our workers safe. And we want you, as an arm of the Environmental Protection Agency, to embrace us all and care about us. Please connect the dots and look at the big picture. It's really important. These permits should be denied. We respectfully request that Ecobat be relocated and that we live more in harmony, protecting them, protecting ourselves, and protecting our entire land, our water, and our air. I'm even having trouble breathing right now because of the pollutants in the air caused by the fires. How much more damage are we going to cause ourselves without having any consideration for humanity and the future of humanity? Please take this in consideration, and we respectfully request that Ecobat relocate and that the permit be denied.
Thank you.
Thank you.
Thank you very much. Okay, the next one is Mark Hoffman. Following Mark Hoffman, please be prepared. I apologize for mispronouncing. Tice Jordan, followed by Art Loza, followed by Boys and Girls Club, and then Ozzy Martinez. So right now, Mark Hoffman.
Thank you. Good morning, members of the board. My name is Mark Hoffman. I'm the Environmental Director for Ecobat Resources. Ecobat's new operating and post-closure permits are the result of years of technical review by our engineers, consultants, staff, in conjunction with DTSC, the direction, their input, and their oversight. This has resulted in commitments by Ecobat to invest in further environmental protections at the facility. Over the past 20 years, Ecobat has invested more than $50 million in environmental and operational improvements to make the facility state-of-the-art in our industry. Our West for wet electrostatic precipitator is a good example of one of the many investments that we have made over the years. This air pollution control equipment enables Ecobat to achieve some of, if not the lowest and safest emission levels in the world for this type of operation. Continuous improvement makes us better each day. Ecobat wants to continue on this path forward toward continued improvement. That can only be realized through the mechanism that allows further environmental upgrades at the facility to move forward, which is our operating permit. Without this permit, we cannot implement a number of these additional equipment upgrades and facility improvements. I'd like to emphasize improvements. The team at Ecobat operates in not only a fully compliant manner, but does so with impeccable housekeeping that anyone who visits the facility can attest to. We're proud of our operation and appreciate your support. And while we understand and support the permitting process, a full stay does not preserve the status quo, it delays meaningful environmental improvements. We support the narrowly tailored approach that the board has presented, this appeal, allowing some of these improvements to proceed as soon as possible. Ecobat appreciates your consideration. Thank you for your time.
Thank you. Next person, Thais Jordan.
You pronounced that correctly. Thanks. Good morning, board members and staff. My name is Thais Jordan. I'm the Vice President and Plant Manager of the City of Industry Ecobat facility. The biggest part of my role there is to oversee the operations, the day-to-day operations, compliance, and the continuous improvement throughout our facility, with a primary focus on the safety of our staff and the surrounding community. Our facility provides 250 well-paid union jobs, many of which sit over here today with us. Many of the guys that we have on staff have worked for us for decades. Some of the longest standing members of our teams in the last year who have retired collectively have 51 and 52 years of service each in our facility. We have multiple generations of families who work in our facility who has worked and still works in the facility. We see ourselves as part of the community, as part of you all, and we are committed to safety, and we have an unwavering commitment therefore. We operate in your community, in our community daily. We have some of our employees, which you'll hear from now, who live in the community amongst you. And we are constantly working on improving our operations and strengthening our recycling processes. Under our current operations, like Mark said, we maintain a robust system of environmental controls. Some of those controls include engineering containment systems, leak detection systems, and groundwater monitoring that has never picked up any releases from the facility. But with a new permit, it enables us to enter the next phase of our improvements and is essential to advance our critical environmental improvement projects, which ultimately would further enhance the safety and performance of our operations. One key example, for instance, is the dewatering project that we have. This project will enable us to convey lead-bearing material and early separate the fluids in this material. It would allow us to not handle those fluids on the batch house floor, but transfer it straight to our wastewater treatment. So the pieces of equipment that are affected are our compression auger and centrifuge. So these are the types of projects that are ready to move forward, but a full stay would delay these important environmental and safety improvements. Thank you.
Thank you. Next person is Art Loza.
My name is Art Loza. I'm here today on behalf of Teamsters Local 986. Thank you for the opportunity to speak regarding Ecobat's City of Industry facility and the renewed permit before the board. For decades, Teamster members have worked at the facility and helped to make critical part of California's recycling manufacturing infrastructure. These are skilled, dedicated union workers who perform demanding work every day and with professionalism, accountability, and a strong commitment to safety. The men and women who work here are more than employees. They are parents, homeowners, taxpayers, and active members of the communities that they call home. The family supporting union jobs provided by this facility have created economic opportunities and stability for generations of working families throughout Los Angeles County. Teamsters Local 986 has actively engaged throughout this permitting process. Over the years, our members have attended public meetings, participated in hearings, and stood alongside community and business leaders in support of both workforce and continued operation of this facility under strong regulatory oversight. We understand and appreciate the importance of protecting public health, worker safety, and the environment. In fact, our members have have a direct stake at ensuring those protections are effective because they work at this facility every day. That is why we support the renewed permit and a strong requirements it contains. The renewed permit represents years of review, public input, regulatory scrutiny. It includes enhanced operating requirements and additional safeguards designed to strengthen environmental performance and the workplace protections. Delaying the implementation of those improvements serves no one, not workers, not the community, and not the environment. This facility also plays an important role in California's recycling system by recovering and reusing critical materials that might otherwise be discarded or processed outside responsible domestic recycling channels. The work performed here supports both environmental goals and good paying union jobs. We respectfully urge the board to allow the renewed permit conditions to take effect during the appeal process so that the benefits of these strong protections can be realized without further delays. On behalf of Teamsters Local 986 and the hardworking men and women we represent, I thank you for your time.
Thank you. Next one is Boys and Girls Club.
On behalf of the Boys and Girls Club of West San Gabriel Valley and Eastside, we are proud to express our support for Ecobat's continued permitting process for its City of Industry lead-acid battery recycling facility. For many years, Ecobat has been a valued community partner and supporter of our mission to empower young people to reach their full potential. Through its investments in local programs and educational opportunities, Ecobat has helped us provide meaningful experiences that inspire youth to explore science, technology, engineering, and environmental stewardship. Their partnership has contributed to expanding opportunities for thousands of young people throughout our communities. The City of Industry facility plays an important role in California's environmental sustainability efforts. Their commitment to responsible recycling and ongoing investment in environment controls demonstrates that sustainability and community partnership can go hand in hand. As an organization dedicated to preparing the next generation of leaders, we believe it is important for youth to see examples of industries that prioritize innovation, environmental responsibility, and community engagement. Ecobat has consistently demonstrated these values through both its operations and its support of local organizations like ours. Thank you for your consideration. We respectfully urge the board to support a timely permit determination for Ecobat City of Industry facility so that it may continue supporting a critical component and a committed partnership to the communities it supports. Thank you.
Thank you. Next one is Ozzy, and then I'm going to call up the next set of names. Following Ozzy will be Sharzed, Andrea, Christine, and then Rachel. Ozzy, you may go ahead.
My name is Ozzy Martinez, and I'm proudly worked at Ecobat for 12 years. I'm more than just an employee at Ecobat. I'm a lifelong member of the community. I live minutes away from the plant, and for the past 30 years, I lived and raised my children there. The health and safety of my family, the safety of my neighbors, and the environment means as much to me as my job and work does. For the past 9 years, I've served as a West technician. monitoring systems that prevent harmful materials from being emitted into the air, ensuring that we stay in full compliance with regulation and permits. My union brothers and I take pride in what we do. We work in full transparency. Every action that we take requires proper permits. The pride we have in our work reflects how much my fellow Teamsters and I care about the well-being of the community around us, our environment, and our health and safety. Our health and safety is number one goal every day. We all want to go home as we came in, safe and healthy. I understand the fear and the opposition, but the reality is we are doing everything possible to protect the environment and our health and safety. Ecobat is committed to improve through investments in the facility, including those in the new permit. I fully support Ecobat's permit. It's about keeping the air and the water clean, preserving good jobs, and securing a better future for our families and our neighbors.
Thank you. Real quickly, just announcement for those participating on Zoom. Now is the time to please raise your virtual hands if you wish to comment on this agenda item, and I will turn to you once we're done hearing the in-person comments. Sharzad, go ahead.
Thank you. Good morning. My name is Sharzad, and I'm a resident of West Covina and represent the 200 members of the San Gabriel Valley Progressives. I'm also a member of the Clean Air Coalition. I'm here to express grave concerns related to Ecobat's application approval by DTSC and to the ability of Ecobat to proceed with their work despite a pending appeal. Ecobat's application for permit renewal was approved by DTSC without Ecobat adhering to DTSC's own required procedures. Those procedures included, number one, a professional engineer's assertion that the applicant met all regulations related to managing hazardous waste. And number two, that a professional engineer's assertion that the applicant addressed potential risks to the environment and human health. DTSC went forward with the processing of the renewal application despite Ecobat's failure to meet those requirements. Instead, DTSC gave Ecobat alternative conditions to pave their path toward permit approval, and then proceeded to approve the permit. While those limitations and mitigation efforts weren't adhered to, there is a requirement that each building containing or storing hazardous materials must meet safety and health standards. But DTSC itself did not say that the containment buildings met those requirements, and again, put through alternatives in order to help Ecobat proceed with their permitting process. I believe that Ecobat's history of negligence insofar as their duty to assure public health and safety and their inability to comply with DTSC's regulations in the past in addition to DTSC's dismissal of past violations by inserting conditions on those violations is irresponsible and does not offer the type of relief to us residents that DTSC's approval of this permit assures the health and safety of the surrounding community. I strongly urge this board to keep the stay on Ecobat's permit while the appeal is pending and to accept all parts of the petition before proceeding. Ecobat asserts that there are small changes that are now required to continue with their permit process and renewal. When I was a children's social worker and the court made a decision and an appeal was filed, no further action was admissible until the appeal process was completed. I don't understand why this body can't do the same. And why does Ecobat need approval of their permit in order to proceed with improving the safety of their facility? They should have been complying with prior DTSC's corrective action plans on an ongoing basis and be laser focused on containing the emissions of their hazardous materials. The stay should remain in place in this entirety until all issues related to the appeal have been resolved. Thank you very much.
Thank you. Next one is Andrea.
Thank you, everyone. I've listened to some of the comments here today,
and the DTSC lawyer said it's the same facility. That part is, can you hear me now? The DTSC attorney said, his words, it's the same facility. It's the same corporate greed. It's the same serial violator. It is the same company, I'm not talking employees, it's the same company that has resisted every effort to regulate them, supervise them, monitor them, fine them all along for years and years and years. When is it going to end? When are the employees going to be protected? I'm a former union local president, a founding member actually of a local labor union. I know what it's like to run the efforts to try and protect employees from things that are inappropriate, wrong, or downright illegal. You have to fight back against that. I don't see that with their employees. And you can't tell me that this company can have so many violations over and over and over that they comply. They don't. They fight you, they resist you every step of the way. Process is critically important. Make sure you follow those processes and deny this permit. And I'd like to say one other thing. Our neighborhoods are being bombarded with pollution. It's not just them. It's them over and over and over and over for many years. It is the regulatory agencies who should be regulating effectively. You're not effective, but you can be. You can do the things and you can make the decisions in these processes along the way that will help protect the neighbors. I can tell you, I had, let me say it that way. I had several friends who lived directly south of Quimeco. They lived there for like 40, 50 years. One died of leukemia. That's one neighbor. The other one, she died of complications of lung disease, and they weren't able to save her. Her husband, he died of leukemia. Their daughter, she left and moved to Tennessee from our neighborhood where she had been most of her life because her last living relative in this area moved back to where all the family came from in Tennessee. And they didn't want to leave her alone. If I may finish just this last sentence. She didn't want to be left here alone. She was afraid of being sick. When she moved to Tennessee, she already had stage 4 non-Hodgkin's lymphoma. She also had to have her thyroid removed. Are these things you're hearing today from other speakers about issues? I have one other friend in the neighborhood, not right where they were, but just a little bit west and a little bit north. 5 dogs, 3 cats, and their goat all died of cancer. Now, you're seeing a repetition here because it keeps repeating itself. Do the right thing. Ultimately, deny their permit, but do all the steps in the processes up to that point to get it to denial. Thank you.
Thank you. Next person is Christine.
Hi. I'm a new resident of Avocado Heights. I moved in 2024. I just happened to have my soil tested right then and there because the crew from UC Irvine was coming through. And at that point, the lead levels were at 108 and the arsenic was at 8. And this year, the students at Cal Poly retested, and now it's at 118 and the arsenic is at 15 and a half. So I'm terrified. I'm already shopping around, thinking that maybe it's not safe for me to live here. And at the same time, I appreciate the willingness of Ecobat to perform voluntary compliance with certain conditions. But at the same time, I hope we can all realize how goofy that is if I agree to voluntarily comply with the road laws, I don't have a driver's license. It's not a thing. It's not acceptable to this community to rely on voluntary compliance for something that's so important. I also recently got goats, and one of the baby goats at 4 months old has a giant tumor on its neck, and it's going to die of cancer. So I don't know. I mean, there are lots of other polluters in this neighborhood, but I don't think that makes it any more acceptable to just accept voluntary compliance, accept improvements. When we accept improvements as necessary, what does that mean? It means that there's something wrong now. And for all of my neighbors here who have lived here for, 20, 50, 30 years, I live surrounded by people who've lived in the neighborhood for at least 20 years on all sides of me. They've all had family members, pets, relatives die of bad cancers, struggle with mental health issues. A lot of those things can be related to lead and arsenic exposure. I don't necessarily know what the correct answer is, but I know what the correct answer isn't, and that is allowing the full stay to be lifted. We just can't, because it allows a permit to become entrenched in history without allowing the community to have its appeal fully heard. And it telegraphs that decision. We're going to not take you seriously again. We're not going to allow your exposures to be counted. We're not going to revisit the health risk assessment that everyone is complaining about. And I really think that, I hope that you'll take our concerns seriously and just keep the full say. No one suffers. Ecobat continues. The community continues to suffer. We should be okay. And, my property is available. My neighbor also volunteered his property for the air monitoring station. A lot of these improvements can be completed voluntarily, and I think we should explore that option. Thank you. Please maintain the full stay.
Thank you. Next person is Rachel.
Hi, I'm a member of the Clean Air Coalition, and my name is Rachel Ochoa Cervera. And of course, I am here to support our appeal to oppose the permit renewal, because basically Ecobat, sad to say, is a very bad neighbor. So many people here have already said what I had already prepared to say. So basically, I'm going to, in 2 minutes, give you a recount of how I arrived to this community. So, and how I feel that my whole life has kind of been based on many injustices. So my former family first got displaced from Chavez Ravine. And then the family moved to Boyle Heights. Look what's happening in Boyle Heights now. If we had stayed there from Boyle Heights, my husband and I were young, just married, and had come over to Avocado Heights, and that was 54 years ago. So we come into this community because we saw the street called Workman Mill Road as a dirt road. People would sell flowers and produce. You say, whoa, this is a great community to settle in. So now fast forward to where we are now. We are beyond 76 years old, and we have been exposed to these toxic chemicals all these years. We have no place to go. We cannot resettle or any place else. This is our home. And can you imagine living a life where you just depend on going from blood work to blood work, or physical to physical, test to test, imaging to imaging, hoping that you don't hear your doctor say that you have cancer? This is how we live, but especially living in this community, having been exposed from Quimetco, and there is no covering up. Isn't it a coincidence that they went from Quimetco, an unfriendly name, to Ecobat? Having been a teacher for almost 50 years, we used to use this little piece of the word eco to make it seem like it was a environmental good thing. but it really is an environmental good thing. So speaking on the people who spoke on their animals, over 50 years, my husband and I are lovers of German Shepherd animals. The first 3 animals, when we didn't know better, they lasted only about 10 years. We learned now from being in CAC that we cannot leave our German Shepherds outside, not even at night. Can you imagine living like that, that your famous pet cannot protect you? But mainly, please follow the comments of today and consider us in your positions. Thank you very much for having us listen to speak today. Thank you so much.
Thank you. Next, the last few on the sign-up list for those that are commenting in person. There's about 4 more. That will be Armando, followed by Daniel, Samuel, and then Michael.
Good morning. My name's Armando Cervera. I'm a member of the community. I've been here over 50 years. And the reason I'm here is to explain something to you. I'm a Vietnam era vet. I'm disabled. I have a couple of Purple Hearts. And when I went to VA, I told them about the Agent Orange because we were told, I was there at the time, and I was told it was safe. When I went to the VA, told them I have to hear all this, what can I do? They gave me a list of all the diseases and all the problems that they had with this particular chemical. And they told me, if you develop any one of these, come on down. We'll see what we could do. So it's like after the fact, I have some kind of disease or some kind of cancer, then come back and we'll see what you could do. You just hear right now, I heard people come in, oh, we're so safe and we do this. And if you give us a permit, we're going to extend all the safety. We're going to have all these safety features. Why aren't they in there now? Why aren't all these future presentations of these fantastic safety features not enrolled or not put into effect at this time? Because of cost. It just costs too much. So the same thing is, give us this permit and we'll give you the safety features. You look back at what they have. Look back at all the violations that this company has had. So how long? I heard, oh, they're good for the community. And I heard that they gave over $1 million to one of the school districts there for the kids to develop leadership programs. You get enough lead into the kids, there's not going to be any leadership people coming out from those schools. It's a safety. When I look at myself now, and I look at workers at Ecobat, and the only thing I could really say is I hope they have insurance for the rest of their lives, and also for their families, because when you work in the environment that they do, you're going to take some of that back to your home. So when I look at this, again, I say everything's coming after the fact. We're going to put better features on safety after you give us this permit. We're going to be better neighbors after you give us this permit. So if they're a multi-billion-dollar company, why don't they move to a place where they're not that dense a population? Cost. Their billion-dollar company might not be making that much more, but it's still, if that's a real safety feature, move out of the area. Thank you.
Thank you. The next person is Daniel.
Hi, board. Good to see you. My name is Daniel Talamontes. I'm with Clean Air Coalition and the Central Valley Air Quality Coalition. I just drove down here from South Stockton, dealing with stationary sources here. You know, listening to so I haven't prepared a comment. This is all coming from the heart and reacting to what I've heard. What I've heard so far is now Ecobat claiming that they need the lift on the stay because it's essential for their environmental protections. Having worked against and been to all these meetings, the support hearings, permits, et cetera, Ecobat has been claiming that they've been perfect for all these years. They don't need extra. They don't need more help with their environmental protections. They've already been doing it. So what does the stay really matter? There's a contradiction in that. I don't really get it. Beyond that, I live here part-time. We're dealing with air pollution coming from Boyle Heights, a facility, a state-of-the-art facility, is all of a sudden having a chemical fire. I'm breathing it. The last week I'm here, losing sleep, coughing. My pets have to go inside. A month before, just miles away, we almost dealt with a chemical bomb from a facility. Our agencies are captive. These are captive agencies. You guys, I work with CARB all the time. I work with air quality districts. You guys perform a unique feature. This board is really unique to DTSC. Why? Because this intervention was critical, because DTSC was deeply flawed. They had been committing continuous errors, specifically with Exide. So you guys need to perform the function as our protective layer, because that was the role. Tony, you're new. Reese, you're new. Having met you before, I'm deeply saddened to see the other two have gone. So this is the stakes. We have children here. We have families here. These are marginalized communities. We have been enduring this from Central Valley to here for our whole lives. My family can't even drink out of well water. It poisons all our cats. We have horses in our stables. They're dying. We have to put them down. We can't even afford to bury them. So we have to, pull all the money together from the TIOs, from everyone else, because they're dying at irregular rates. You guys perform a unique function to protect us. You were put here because DTSC has failed constantly. And it's our own tax dollars that have to pay for it too. Okay? So do better and help us, please.
Thank you. So last call for in-person commenters. If you would like to comment today, please come over here so you can sign up. Then the last two for in-person commenters, otherwise, will be Samuel, followed by Michael.
This appeal is not about whether lead acid batteries should be recycled. It is about whether California's hazardous waste laws mean what they say. Your responsibility today is not to determine whether Ecobat provides an important service. It is to determine whether the Department of Toxic Substances Control followed the law when it issued this permit, and whether the public's right to meaningful appeal is preserved while those legal questions are decided. For decades, the community surrounding the facility have borne the risk associated with hazardous waste management. This facility is located within an SB 535 disadvantaged community that has experienced disproportionate cumulative environmental burdens. Residents have lived alongside hazardous waste operations, industrial emissions, contaminated soil, and heavy truck traffic for generations. They have attended meetings, submitted comments, reviewed technical documents, and participated in this process in good faith. The question before you is whether that participation has real meaning. The Clean Air Coalition's appeal challenges the legal foundation of the permit itself, not merely individual permit conditions. It raises substantial questions regarding the protectiveness of the permit, DTSC's permitting decisions, the adequacy of the administrative record, compliance history, public participation, and whether the permit satisfies California's hazardous waste laws. Ecobat and DTSC argue that the renewed permit contains more than 100 new conditions intended to strengthen public health and environmental protections. But that argument reveals a fundamental inconsistency. If these additional conditions are necessary to adequately protect public health today, then they acknowledge that additional protections were needed. That is precisely why this board must ensure that the renewed permit was lawfully issued before allowing those disputed provisions to take effect during the pendency of this appeal. This community continues to bear cumulative impacts. Nearby, Palm Elementary School in Hacienda La Puente Unified School District has been closed for over a year because of documented concerns of contaminants, including lead and arsenic. Mind you, this is the closest elementary school to the lead battery smelter. Children should not be asked to shoulder additional environmental risks while serious legal and factual questions remain unresolved. The board should also carefully consider evidence raising concerns regarding the apparent operational use of adjacent property in connection with hazardous waste management activities. If regulated hazardous waste operations have occurred beyond the permitted facility, then that needs to be challenged and the appeal must be honored. Thank you.
Thank you. Okay, last call. Are there any additional folks that would like to comment in person? And you have not yet signed up. Okay, Michael, you may go ahead.
Good afternoon. My name is Marco Contreras, and I'm here today on behalf of the Los Angeles County Federation of Labor. We represent over 300 unions and over 800,000 union members in LA County. The Los Angeles labor movement has long supported responsible employers that provide family-sustaining union jobs, maintain safe workplaces, and contribute to the economic vitality of our communities. Ecobat's City of Industry facility has been one of the most important employers for working families in this region. For more than a decade, labor organizations, Teamsters, retirees, community leaders, and local advocates have participated in this public process. Throughout that time, we have consistently emphasized that the voices of workers who operate this facility every day deserve to be heard and considered. This facility plays an important role in California's recycling infrastructure, domestic manufacturing supply chain, and broader environmental sustainability goals. The dedicated men and women who work here help ensure that critical materials are safely recycled and returned to productive use, while supporting their families and contributing to the local economy. We firmly believe that environmental protection and good union jobs are not competing priorities. They are complementary goals. Strong permit requirements, rigorous environmental safeguards, workplace protections, and a highly trained union workforce are essential components of a responsible industrial operations. The renewed permit before you today has been more than 10 years in the making. It is a product of extensive technical review, regulatory oversight, and significant public participation. Importantly, the renewed permit contains enhanced requirements and stronger protections that will further modernize equipment operations and improve safety moving forward. At this stage, we respectfully urge the board to avoid unnecessary delay and allow these strengthened permit conditions to take effect while the appeal process continues. Delaying implementation only postpones the benefits of the permit's enhanced safeguards and creates uncertainty for workers, their families, and an essential California recycling operation. Labor has stood with these workers throughout this process because they deserve stability, fairness, and recognition for the important work they perform every day. We are proud to stand with them again today. On behalf of the Los Angeles County Federation of Labor, we respectfully urge the board to allow the renewed permit conditions to move forward and to continue this process in a timely, fair, and balanced manner. Thank you.
Thank you. 2 additional comments for in person. We're going to do Ralph, followed by Jane. Ralph?
My name is Ralph Ochoa, and I live in the area for over 40 years. And when you people opened up the talks about the unions and all that, I've been involved with union since over 50 years. 660, 770, 685. And these unions have supported children and everything else. And I know the main thing is they support their workers, but they also support the workers' safety and family and their ways of making a living. So when you bring up that this is going to hurt the community, I think in most of the cases, the companies just get up and move and take the workers with them. I understand they live close, but how far can you go and how can they not afford to take their workers with them? So this thing about it's going to affect the workers and people that live there, I think that's a moot issue. And so I think everybody here can take and listen and look at what's happening, all these things going around Boyle Heights, in Santa Ana, and the fire, a recent fire down the street. So when you open up that thing about unions and stuff like that and children, the children are our future. And the people that live in this community, I moved here because I like it, because we have horses. It's a country-like situation. And people want to run the horses out. You don't have to run them out now. You're killing them. So what is the profit, or what are we seeing by keeping this company open? Thank you very much.
Thank you. And again, last call for those in person. Otherwise, our last in-person commenter will be Jane. For those of you on Zoom, please raise your virtual hands if you would like to comment. I will be turning to Zoom participants after this last in-person comment.
Hi, everyone. My name is Janie Barr. I've lived here in Whittier for over 50 years. And recently, I was diagnosed with breast cancer. After hearing all these comments from these people about people dying, now I wonder if that's me that's going to die soon because of this. And I'm hoping that the board will consider not authorizing or not approving this because I don't think that people should suffer because of them. We should all look at ourselves. Is your money better than your life? Would you rather see your family die because you're worried, oh, I have a good job or I have a good pay? So I'm hoping that you guys are going to listen to us or to me, because I'm a sample of that. And thank goodness they caught my cancer early, that they were able to remove them. But hopefully this will be one of the comments that people should listen to. Thank you.
Thank you. I am now turning to Zoom participants. Please raise your virtual hands or press *9 on your phone if you wish to comment. Ivana Castellanos, I'm going to send you a request to unmute. You have 3 minutes. You may go ahead.
Hi, good afternoon. I'm Ivana Castellanos with Physicians for Social Responsibility, Los Angeles. I've been listening in today and have a couple of observations I'd like to offer. The board was established to serve the public's interest, particularly disproportionately burdened communities. And there are issues raised in this matter that could fundamentally implicate the permit in its entirety, not just specific conditions. Issues that the board staff itself has reviewed and in their presentation today acknowledged that these issues meet the petition criteria. And I'm hearing today from many members of the surrounding community expressing that the proposed limited stay would not serve to maintain the status quo, while those fundamentally broader issues have yet to be heard, and that they have concerns about the implications of a limited stay of the permit. I urge the board to reflect on its mandate and to take seriously the perspective of the frontline communities it serves. I also want to echo some of the earlier comments regarding the administrative record. I'm alarmed to hear that the board decided to accept incomplete record keeping. And in my work reviewing many DTSE prepared materials, similar to what Jenny Knack reported, it's been my experience that agency staff do tend to place a lot of significant context, calculations, assumptions, and other materials in attachments and appendices. DTSE's work is important. We need our government to act and protect our families from toxic pollution, and the agency's decisions and activities directly impact public health. And it is DTSE's responsibility to transparently document and maintain complete records of this critically important work, and to gather and provide those records to the public when requested. This board was established to provide oversight to the agency to increase transparency and public trust. And board actions that do not hold DTSE to these responsibilities only serve to erode that trust. Thank you.
Thank you. Next commenter, Jim Vega. I'm sending you a request to unmute. You may go ahead.
Hello. Am
We
I
can hear
on?
you.
Okay.
Yes, we can hear you.
I'd like to encourage the mercenaries, the lawyer, the engineer, and the candlestick maker. Why don't they bring their grandkids to live on one of those little farms, and let's see, hopefully they don't get sick. Gonna get an amen on that. The last time I was here, my talk was entitled Courage. This time, my essay will be on conscience. The online Urban Dictionary defines it an inner feeling or voice viewed as acting as a guide to the rightness or wrongness of one's behavior. Well, it seems the fates have set a stage for us to make a strong case for denying Timecodes pollution enabling permit. Regrettably, it comes at the expense of the health and safety of residents of Boyle Heights. That would be a community of color, by the way. In case somebody is unaware, the huge fire at that Lineage and Logistics cold storage facility did make the national news. I submit to you that Ecobat Timeco is hoarding on their site. What they're hoarding is a hell of more toxic and dangerous than the solar panels still burning in LA. BES, now is your moment. You can fulfill your prime directive, that being to protect public health from polluters. Full stop. Now is your time to be on the right side of history and do the right thing. Deny Ecobat's permit. As for you, DTSC, pathetic. Get on the transparent accountability. It should be running through your blood. It's disturbing that we must publicly make this demand when it's in your supposed to be in your DNA. Well, people of a certain age may remember the eruption of Mount Redoubt in Alaska some 17 years ago. Bobby Jindal mocked the very notion of volcano monitoring. That Louisiana governor said that instead of spending all that money for volcano monitoring, and so after that poorly timed comment, boom, the Alaska volcano erupted all over Bobby Jindal's face. I suspect the subsequent mockery throughout the land helped derail his budding political career. You people on BES and DTSC don't be that Bobby Jindal. Let me close with this prayer. Oh, Great Spirit, make me always ready to come to you with clean hands and straight eyes. So when life fades as the fading sunset, my spirit may come to you without shame. That's translated from the Lakota Sioux Chief, Yellow Lark. Thank you.
Thank you. Next is Byron Chan. I'm sending you a request to unmute. You may go ahead.
Good afternoon. My name is Byron Chan. I'm an attorney at Earth Justice, and I'm calling to support CAC's right to a full stay of the renewed permit. In its presentation, Permitting argued that the stay should be lifted because keeping it in place would delay protections in the renewed permit. But Ecobat has been operating under its current permit since 2015. So if Permitting believed that additional protections were needed, it has had more than 10 years to address those problems, but it didn't do so. This is not the time to lift the stay, so Permitting can now try to fix problems in the current permit. The board's appeal rules require the stay to remain in place during the appeal. The purpose of the stay is to keep things as they are until the board decides the appeal. Lifting the stay would not maintain the status quo. It would change it before the appeal is decided, and it would prejudice arguments accepted by this board that Permitting unlawfully granted Ecobat's permit. Ecobat said that the new permit conditions are protective, but the board does not have any evidence showing that those conditions are protective. The board is simply taking Ecobat's word on that issue, which is completely unlawful and inappropriate for the initial order hearing. So for those reasons, I ask that the board maintain the full stay of the renewal permit. Thank you.
Thank you. Next commenter, Sophia Ramirez. I'm sending you a request to unmute. Sophia,
Yes, can you hear me?
you may go ahead. Yes.
Good morning, Chair and members of the board. My name is Sofia Ramirez, and I lived in Whittier my whole life. Today, I ask you to remember why this board exists. It does not exist to make permitting easier. It exists to ensure that hazardous waste facilities are regulated lawfully, transparently, and in a manner that protects human health and the environment. For decades, the families living around Ecobat have carried burdens that few Californians would accept in their own neighborhoods. They have lived next to one of the nation's largest secondary lead smelters. They have attended meeting after meeting, submitted comments, organized their communities, and asked regulators to do one simple thing: follow the law. This appeal is not an attack on recycling, it is a request for accountability. The Clean Air Coalition's appeal raises serious questions about whether the permit was lawfully issued and whether the public received the full protections guaranteed under California's hazardous waste laws. Those issues deserve careful review before this permit becomes fully effective. DTSC argues that the renewed permit contains more than 100 conditions that it believes are protective of human health and the environment. But if those new conditions are truly necessary to protect nearby communities, then they also raise an important question. Why were those protections not put in place for so many years? The answer cannot simply be trust us this time. Trust is earned through transparency, complete administrative records, meaningful public participation, and independent oversight, not through assurance after the fact. Ecobat argues that delaying implementation of portions of the permit would postpone environmental improvements, but this board's responsibility is not to decide which side tells the story today. Your responsibility is to determine whether the permit was lawfully issued and whether the public's right to meaningful review is preserved while that question is answered. The board's own regulations provide for a stay during the appeal process. The Clean Air Coalition argues that where the appeal challenges the legality of the permit decision itself, the stay should remain in place until the board reaches the merits. This case will set an important precedent. Your decision will tell communities across California whether hazardous waste permits receive genuine independent review or whether meaningful oversight ends once a permit is signed. The people living around this facility are not asking for special treatment. They are asking for equal protection under the law. When the consequences involve hazardous waste, lead, and public health, the law should be followed carefully, not conveniently. I respectfully ask you to protect the integrity of this process, preserve meaningful public participation, and ensure that the law, not expedience, governs California's hazardous waste permitting program. Thank you.
Thank you. Last call for Zoom participants. If you would like to comment on this agenda item, the initial order for Ecobat, please raise your virtual hands. Anthony Mercado, I'm sending you a request to unmute. You may go ahead. Anthony? You are unmuted. You may go ahead and comment. We're not hearing you, Anthony. If you would like to submit your comment in writing, or let me send you another request to unmute. You are now unmuted. We're having issues connecting with Anthony. If our facilitators can connect with him and try to get him on the line. In the meantime, Anthony, I'm going to move on to our Spanish interpreters. Spanish interpreters, please let me know if there are any comments in the Spanish room. No comments in the Spanish room. I do have 2 comments that are received in writing that I would like to read aloud. First comment is from Lori Potter. I am not in support of the Ecobat toxic lead smelter hazardous waste generator in the city of Industry. I am in support of keeping the stay on the entire permit. Our arguments in the appeal must be addressed with full transparency. This generator is too dangerous to be operating in any community. I am in support of the Clean Air Coalition. The public's health must be supported. The generator should not be allowed to operate using the new permit while the appeals process continues. Thank you, Lori Potter. Next comment we received is from Christopher Lawrence. I am an Avocado Heights resident and a volunteer with the Clean Air Coalition. Thank you for entering this statement into the record. What do Vernon, California, Ohijo, Nigeria, and the City of Industry have in common? They are sacrifice zones, places where dangerous lead battery recyclers poison the most vulnerable members of society. In Vernon, Exide contaminated thousands of homes, walked away through bankruptcy, and left the public to pay the cost in illness and endless cleanup. In Ohijo, journalists tested what regulators would not and found that half the children in the surrounding area carried enough lead for permanent brain damage. We cannot afford to wait for disaster or public attention. We have lived beside this facility for decades and seen its toll in the illness of our families and neighbors. Our cumulative impact ground truthing study found that the average receptor near Ecobat is exposed to 133 dangerous pollutants. Ecobat's record speaks just as, and then it cut off Christopher Lawrence. So if you would like to submit your full comment to us in writing, please do so. I am going to circle back to, okay, we lost our last commenter. Last call for Zoom comments. Otherwise, we will close out this public comment period. Seeing no additional hands raised, Chair Rakestraw, that concludes this public comment period for this agenda item.
Thank you, Sheena. And thank you to each and every one of you for taking the time to travel here today to share your stories with us. We have listened very intently to your comments. We really, really, truly appreciate it. So now the plan is to break for lunch. Board members will, of course, take the time to consider each of the comments that were raised here today. And when we return, we will proceed with board discussion before the board considers the initial order. So to be clear, the direction to board members is not to deliberate privately with each other during this break in order to comply with the Bagley-Keene Open Meeting Act. So the board members will not be doing that. All board discussion occurs in public before all of you. So the plan is to reconvene at 1:40 p.m. I think that gives each of us enough time to grab a quick lunch, and then we'll reconvene here and restart discussion at that point. Thank you again.
We will take a 60-minute lunch break and reconvene at 1:40, where we will continue with agenda item number 3, the initial order on appeal for Ecobat.
So I think we're going to go ahead and resume the meeting at this point. Apologies for going a bit beyond the scheduled time. So board members, we've heard extensive public comment. We've heard extensive comments.
Chair Rakestraw, apologies. For the record, a quorum is established with all board members present.
Thank you so much, Sheena, for that. So we've heard extensive public comments. We've heard comments from the parties. We've received a significant amount of briefing, and now is the time for us as board members to consider all of that, to ask in the first instance questions of both the board staff that are here as well as the parties, and then to engage in a discussion amongst us as board members about the next steps here. So as is usual practice, I think often we'll start with board Q&A. So who would like to go ahead and kick us off and ask some questions of board staff? And of course, that you may also direct questions to specific parties as well. Member Atkins.
Well, thank you. I'll start with one question, and I may have a few others a bit later, but after I hear from some of my colleagues. But a pretty simple question, maybe for our legal counsel and staff at BES. The Clean Air Coalition made reference to the plain language in the law. And I also heard the counsel for Ecobat respond to that. And I think I would like to hear our counsel respond to the issue of plain language based on Clean Air Coalition talking about A and B, and then the response from Ecobat's counsel.
Certainly. So the plain language that we're referring to is section 66271.71 of Title 22 of the Code of Regulations. We've referred to that, and you saw it in my slides, as the stay regulation. There are 4 subsections, A, B, C, and D. And I'll paraphrase those. I don't think we have a slide that shows the language verbatim here, but I can paraphrase, and I'm sure others can speak to this as well. But subsection A states that a stay automatically takes effect and affects the entire permit decision upon the filing of an appeal. So a permit decision does not take effect immediately. There's a 30-day period for an appeal to be filed. And if an appeal is filed within that 30 days, there's an automatic stay that goes to the decision as a whole. So subsection A, the whole decision automatically stayed. Subsection B then is language that our board changed in its rulemaking. So when we're referencing, the board changing the appeal process, expanding the appeal process to include issues as well as conditions, we're really talking about subsection B, because that language states that when the board decides on which issues to accept or review in the initial order, that at that time it also decides the scope of the stay, and it uses mandatory language to say that the board shall limit the stay to the issues that are accepted by the parties. Subsection B then goes on to speak to conditions in the permit that are included in the stay, and also speaks to the idea that we have to make a determination about whether there are other conditions that are sort of intertwined. The language that it uses are capable of being severed, right? So when we talk about, we've determined that these other conditions are severable, we're operating within this subsection B language. So I think part of the dispute here is over, when do we start that analysis? When do we get into this idea of severing conditions? And how do we relate the issues to the conditions and so forth? So I'll get off here in just a second, but just to sort of summarize our position is that we looked for the issues that were raised by these appellants that were related to conditions specifically, right? And where an issue raises conditions specifically, we found it pretty straightforward to say, well, those conditions then need to be stayed within this permit. There were other conditions raised that didn't speak to conditions. And so in those, there's an open question, or it's debatable, of whether you need to continue to have a stay, even though the conditions or the issues themselves don't speak to conditions, right? So that's where I think it's helpful to get into an analysis around protecting the status quo and sort of some of the underlying purposes of a stay.
And that's part of your putting together a staff for our consideration, the initial order.
Correct. Okay. Yeah.
Thank you. My only other question, I'm sure, Mr. Chair, you're going to deal with the timeline request, and so you'll deal with that. But I'll listen to some of the other questions, and I may have another one later if that's okay.
Yeah, that's certainly okay. Who would like to ask questions next? For Brostrom.
I believe this would also be for legal counsel, ours. So, I think we heard, about a couple of subset of issues today. One item that I heard today that I didn't see in the initial order was regarding the scope of the administrative record. And I was wondering if you could provide some clarity in terms of what our role, like why it's not in the initial order. So if you could just clarify kind of, the board's role in that.
Sure, happy to do that. So the initial order, or sorry, the administrative record, there are contentions in the petitions around the administrative record. So there are issues that have been raised around the administrative record. And what those basically amount to is an allegation that during the permit review process, DTSC failed to comply with regulations that speak to the administrative record, how it's assembled, how it's made available, that sort of thing. We've accepted those issues. Those are going to be heard in full on the merits at our public hearing. So that's, you could maybe call that a substantive issue. I don't know if how you want to characterize that, but that's essentially the contention there, that, the permitting process itself, is affected by the compliance with, or allegation of lack of compliance with those standards. Separate from that, when the appeal notice comes to the board, we have an administrative process of our own where we're assembling the administrative record. And it really starts with DTSC providing an index to us that lists off all the items in the administrative record. And we have a process where the parties meet and confer separate from us. They raise contentions about looking at this list, and they might see in there that there's items that they contend to be missing. And so our hope is that they're able, through the meet and confer process, to settle any disputes that they have. We have a status conference where we meet with the parties, go over some of these contentions, and then ultimately we receive motions if there is an underlying dispute about particular documents in the administrative record. And so we have a process that essentially delegates that to the chair and the vice chair. They receive motions, they rule on motions, really for a practical reason, which is that we only meet 6 times a year, right? So to have those go to the full board, it's, we made a determination early on in our process in establishing the standards for our process that would be something that could be delegated in that way. And so here, motions were filed and a ruling came from the chair and vice chair on that. And we consider that to be settled at this point, and it did not result in any changes to the administrative record that we received from DTSC.
So the issue is not before this board today?
Correct.
Thanks, Member Rostrom. Member Williams, please.
Thank you. I wanted to pick up on some comments raised by the public on a number of occasions. Namely that Ecobat is able to implement the permit improved environmental protections voluntarily if the board were to issue a full stay. Is that the case? And if so, it gives rise to the question of what are the merits of a permit at all if it can be done voluntarily. Presumably, permitting improved environmental protections creates a standard and a level of accountability that can be enforced by DTSC, but welcome a response, staff counsel, if appropriate. Thank you.
Yes, so in our process, parties can raise issues specific to particular conditions, and we stay those conditions while the appeal is heard. And it means that if there are new protective measures, new requirements that would be part of this new permit decision, that those are held in abeyance, they don't take effect. You heard testimony this morning around one of those conditions in particular that was around the ventilation system maintaining a negative pressure within the building. It turns out, according to what we heard today, that that's a separate requirement that's also applicable to the facility from another agency, the Air District. So that, I think, is reassuring to us because we are concerned, frankly, about the new permit and new protections, and wanting to see the new protections take effect. I mean, this is the point that you heard from DTSC as well. So why have a new permit at all? I think it's to provide greater clarity. I think that what we see with these permit renewals, these are essentially administrative updates where the facility has been under oversight of DTSC. In this case, there's been compliance measures. There's been inspections where they've found things, and now this new permit incorporates some of those features. So to allow the new permit to take effect means that DTSC can now start enforcing some of those requirements that are responsive to those particular areas that have built up over time. So that's, I think, what I would say in response to.
Thanks, Member Williams. Hold on. Sorry.
You could tell me that I'm out of order.
You're out of order. I don't think the question was specifically directed at our staff council. Sorry.
Just to add on that, I think staff council answered the question I was asking.
Thank you very much. Yeah, Member Atkins, and I also have several questions.
I apologize. Last one, I think. Reference made, and I just want to clarify, and I will ask our council again. I just want to clarify, or staff. Reference was made to a health monitoring analysis and why one report might have been used over another in this 2014 versus 2016. So I just want to clarify that is one of the issues that is going to be addressed through the appeal process.
Correct. Yeah, Marcus, did you mind? She's speaking about one of the health risk assessment issue I think was raised.
Yes, health risk assessment.
Yeah, that health risk assessment issue was raised by two appellants, including Clean Air Coalition and McKee, and they have been accepted. So the merits for that issue will be discussed at a future date.
Thank you.
Thank you very much, Member Atkins. I think Vice Chair Strauss-Hacker is, and then Executive Officer.
Thank you. It's specific to Board Member Atkins' question on the human health risk assessment. A statement was made this morning that human health risk assessment, whether 2014 or 2016, may be, quote, incomplete. Someone attributed that statement to the director. I know we have accepted Mr. McKee's issue number 4 and Clean Air Coalition issue number 4 for the appeal on this particular matter. I'm just ignorant of whether that document is considered complete and final, or does it get revised pending our hearing the full appeal, or does it just stay as is in the administrative record, and whatever the board may elect to do with that matter come January will determine whether there are any updates or changes to that. Do I understand that?
Right. I think that's right. So I believe there's been an allegation that there are certain requirements that are applicable to a health risk assessment. And there's been an allegation that those have not been satisfied, and that the health risk assessment that is currently available and included in the admin record is insufficient or deficient, lacking in certain ways. So if the Clean Air Coalition is successful, carries their burden to prove that those that it is in fact flawed, then it would be up to the board then to fashion an appropriate remedy to cure those defects and direct that and remand.
Thanks. That helps me. It's both Mr. McKee and Clean Air Coalition's issue. Mr. McKee, number 4, Clean Air Coalition, number 4. Okay. Thank you. That helps.
Thank you very much. Yo Sharma.
I was just going to remind board members that you can direct your questions to other council here as well, or all the other parties. So.
Reminder. Why don't I go ahead and I'll jump in with a few questions. Just flagging for DTSC that I do have a question for you. So if you could get ready for that. But I'll first start off with our board council here. I just want to clarify what this draft initial order in front of us is and is not. And I just want your clarity on that. So I guess the first thing is, with respect to the scope of the stay, I just want to be crystal clear that this board retains the ability to provide all relief that is being requested, including directing DTSC to ultimately deny the permit, kind of regardless of what goes, if in this draft as presented. Is that correct?
Correct, yes. So I think we've tried to make that as clear as we can, but I appreciate the reinforcement of that concept, because we are accepting issues to be heard by the board on the merits. And what we intend by that is that relief can be granted on those issues. And some of those issues dispute the permit as a whole and call for a remedy that requires DTSC to repeat the permitting process, or even going so far as to go the other way and to start proceedings to deny the permit. Now, we're a long ways off from making that decision, but that's in the realm of possibility, and it's within what we reasonably anticipate as being a possible outcome in this appeal.
Thank you very much. My second question is, within the analysis that you have proposed here on the scope of the stay, in terms of disentangling conditions from issues and so on, no part of that analysis included an actual assessment of the merits or the environmental protectiveness of the draft permit or the permit. Is that correct?
Correct. Yes. So what we've done is we've looked at allegations in issues that have been presented and looked for how those relate to conditions. Are those conditions put at issue? Are they contested? Are other issues severable from those? And that's really been, the great focus of our approach to this work.
Thanks so much. I think there's some drafting that would need to be cleaned up based on that. On page 37, lines 15 to 17, it does say, for this facility, a limited stay will enable measures that have not clearly been contested by the appellants and that appear to be protective to take effect, which better aligns with the board's mandate and so on. So I think I would, depending on where this goes, would need to see that changed to reinforce that point that you just said, that this did not actually consider the health protectiveness or not, or is not a judgment on that. I think that is very much an issue that is for the merits. I think that's reinforced as well. I also wanted to make a point as well on page 39. There's this is kind of the second drafting issue that I wanted to raise in lines 19 to 21. I don't think it's a fair characterization of the issues that CAC are raising to call them kind of procedural issues. And so I think we need to fix that drafting as well. I think, under that standard, every issue is procedural, but these really they're kind of issues that go to the heart of the permit or go to documents that informed every element of the permit. And so when we get to that point, I think I would need to see some changes to that bit as well.
Yeah. So what I think we would want to say there is that there are some issues that maybe are not reducible to conditions. Characterizing them just as procedural, I think that's probably not the most helpful phrasing, but to say they're not reducible to conditions, I think is in alignment with much of the bulk of that initial order. And hopefully that would address your concern.
Thanks, Board Counsel. And my last question is for DTSC, as I previewed earlier. I don't know if counsel for DTSC, this would be most appropriate for the legal counsels. But the other DTSC staff are also welcome to come up as well. And so my question is basically, I read many times the pleadings that DTSC submitted on the scope of the stay, and the assertion that there are over 100 health protective conditions that are in there, and kind of for that reason, the scope of the stay should be lifted. But there's there was no, I didn't see at least, legal analysis to kind of make that connection. So I was wondering if you could shed some more light here, or if you have anything else to add to that with respect to any legal analysis to kind of connect those dots. Thank you.
I think the best is to, because we understood that the board has the authority in determining the scope and effect of the stay. And we, as was our position before, that we wanted to just defer to the board. But overall, the permit is a massive upgrade compared to the old one. So in that sense, we're saying that there is a health benefits that will take place as these permits gets implemented. and take place.
Okay, thank you very much. And then, sorry, my last question, sorry to go a bit long here, and I think this, I guess would probably be best for board council again. I'm sorry. Thank you very much, DTSC. Would be, so, under your proposal here, there are certain permit conditions that are allowed to, I guess, temporarily take effect. Who is assuming the risk of that? Just because I want to make sure that there is no, I think you've made clear that, if the board allows, there's limited legal risk, right? That was kind of my first question, which is like, do we retain the ability to provide any remedy that's being requested by the parties? And you answered yes. So that kind of gets at the legal risk, but there's also this like factual risk of like, the situation has changed on the ground. Ecobat has made certain process or changes or capital investments, and therefore it becomes more difficult for this board to actually grant those legal remedies. Who assumes that risk? Is it Ecobat? Are they basically proceeding at their own risk, and we in fact retain that ability to provide that relief?
Yes. So there are two areas of new construction facility renovations that are authorized by this permit. One is the battery storage area. It's going to be repaved. There's going to be berms constructed. The other one is this containment building. Floor is going to be ripped out. It's going to be completely redone. To your point, if those were allowed to go forward, if Ecobat was given the authorization to proceed with those today, by the time this matter is heard, it would be effectively too late to make changes there. And so it sets up this concern around risk. By staying those conditions, we're preventing that construction from occurring. So that's why I feel confident that this stay has an effectiveness of maintaining the status quo, because Ecobat is being prevented from incurring the costs and won't be in a position later to claim that, well, we've already, as a practical matter, completed these improvements, and so therefore there's nothing left for you to do. So until this matter is heard and decided by the board, Ecobat is prevented from doing that work. So it's not a matter where they have to proceed at their own risk or something like that. There would typically be a sort of a kind of an analysis around that, like you'd have with a brand new facility. I think to keep in mind, this is an existing facility. They already have authorizations for almost all of these units. And there's really only two areas of actual physical renovations occurring.
Thank you very much. Member Brostrom is requested first, and then Vice Chair Strauss-Hacker. Please, Member Brostrom.
Yeah, and this is related. And thank you for that line of questioning. It's a very similar line of questioning that I had, which is what I heard from community members was this idea that if we lift the stay, then there's we're presupposing the outcome, that we're creating prejudice for a certain outcome. And so, as I listened today, the description of the stay, my mind kind of went to like, there's two kind of categories, things that require a capital outlay or expenditure indeed, even if they're not part of the challenge conditions. And this is going to get to my questions. Any capital expenditure made in reliance on this permit could lead to this idea that there's a presupposed outcome. On the other hand, there are a subset of conditions that are more process or procedural or different activities, which I think carry a lot less risk of there being some sort of prejudice there. So I know that you named two capital expenditures. What about, aside from the challenged conditions, any other capital expenditures? Because again, we don't want, there to be reliance on this permit that is being, the request is to, to not uphold the permit approval. And so just wanting to make the distinction about activities, low risk, and any capital expenditures, which would be a higher risk, even if it's not related to a challenge condition. So can you kind of explain?
Yes, I'll do my best. So there are quite a lot of conditions in the permit, and I think by and large, they're responsive to areas of concern that have come up during the life of the last permit. They're trying to, as was stated, make upgrades to the facility. And they do that through physical changes, renovations, the containment building floor, this battery storage area. There's also another project. It's not really governed by the permit, but Ecobat is working to expand its stormwater capacity. And so it's pursuing that already independently with the city. And so there's a condition in the permit that speaks to the use of certain stormwater tanks. The idea there being Ecobat needs to make good progress, show good faith toward pursuing that improvement, and controlling the use of these tanks is a way to ensure that that occurs. That's not part of the stay because, well, if we stayed that condition, then it removes this sort of leverage that might occur that would, encourage Ecobat to do that. So that my understanding, and I think you're going to need to hear from the facility themselves directly. It's, to be able to really speak to this more fully, but I believe those are the areas that relate to physical improvements and, capital expenditures, all that sort of thing. There's other equipment at the facility that's being authorized by this permit. Most importantly, there is this dewatering system, this auger, centrifuge. That equipment's been installed in the facility. It's just not operable. So there's an authorization that they need to operate that equipment. I think that belongs in that second category of operational changes because it's already in the facility. It's not something that they need to install. It's just given authorization to do it. There are other procedures or sort of operational adjustments, standards that apply to their process and how they approach their outreach to the community, and air monitoring and things like that, somebody that's more adept and steeped in all the specific conditions can speak to, but those are allowed to go forward unless they've been specifically challenged by the petitions. So that list of the 15 conditions was our best effort to distinguish between those matters that are being challenged, that do need to be stayed so that those issues can be preserved and heard, versus when we say that other conditions are severable, it means that no one's challenging those particular changes to the facility operations. And to DTSC's point, they consider them to be for the good.
So make sure that I'm hearing correctly. So the two things that might be not challenged but require some capital outlay is this stormwater project that is shared jurisdiction with another agency, and 2, equipment. Is that a fair assessment?
I mean, I would say the equipment is not an outlay. It was years ago, but at this point it's installed. I mean, we've toured the facility, we saw it, it's there. Like it's not a capital outlay at this point,
Thank you very much. I think Vice Chair had a question related to this as well.
Perhaps you and representatives for the facility could help me with this. So we've taken on or are proposing today to take on Clean Air Act Coalition issues number 6 and 7, and they relate to equipment like the compression auger and the centrifuge, and correct me if I misspeak. Does it mean that with those conditions stayed, I'm trying to separate out what a facility cannot do with those conditions stayed and what they can do in normal operational stuff, that day-to-day operations or 24-hour operations that continue from this point forward, authorized by the new permit, if the board were to accept what is in the staff recommendation?
Right. So what we found was that there were conditions that had specific authorizations as part of the condition, right? So I mentioned battery storage area, I mentioned the containment building. Yeah. There's an actual condition in the permit that requires the facility to submit to DTSC for an approval and then to go and perform construction based on that approval. So we're staying those conditions, we're preventing that authorization from occurring. Ecobat cannot submit to DTSC, DTSC cannot authorize it, it's stayed. There are other, there's other equipment at the facility that is just allowed by the permit that is not in a condition per se, right?
Yeah.
So there's a condition that applies to a number of different pieces of equipment in the facility related to air quality and the negative pressure. That stayed. There's another condition that requires inspections of pieces of equipment that stayed, but there's no condition itself that authorizes, the dewatering system, for example, or some of these other features. They're just encompassed within the new permit because they're called out as units, and there's just a broad authorization to operate within these different units. And some of those units are now considered units. They're existing pieces of equipment like the hammer mill. That's been in operation from the start. It's just now it's being identified as a hazardous waste management unit. There's not a particular condition that speaks to the use of that equipment. It's, not covered by a condition. Right.
One follow-up to that, if I may. With regard to South Coast Air Quality Management District's permit, which may have its own condition or multiple conditions with regard to negative pressure, we are proposing to accept that matter on appeal, and it would be stayed. So does that put the facility in the position of having to comply with South Coast while it is to be heard by this board if the board accepts that recommendation?
Right. So the Air Quality Management District, of course, their permit is not affected by anything that this board does. So the facility remains subject to that permit and would be in violation with that permit were it to violate any of the terms of that permit. Yeah. So it operates as a gap filler because there's an overlap on that particular equipment.
Thank you.
You're welcome.
Thank you very much. Vice Chair Strassacker, did you also have a question for Ecobat Council as well, or no? Okay. I did actually. I had a question. I wanted to ask kind of that same question about the kind of weighing or like who is kind of of Ecobat like assuming the risks of moving forward and like any expenditures and so on. And if you agree with the analysis that our board council put out with respect to the line of questioning from Member Brostrom, myself, and Vice Chair Strassacker.
I do agree with what Greg said. Getting to the first question that you asked, Chair, any expenditures that are going to be incurred by Ecobat as a result of proceeding under any conditions that become effective after today, that's the risk that Ecobat is willing to take on. Again, as I said at my earlier presentation, Ecobat wants to begin these projects, even if they cost money. There is no objection from Ecobat to incurring costs to perform an activity that may have to be undone at the conclusion of this activity. That is not something that we have take any issue with. And I would, represent to you guys that you're not going to hear from me if we're in January and we're arguing over this. But wait a minute, you guys, this is already done. I mean, that's just not a defense. We are willing to take this on and do this work at risk. There were a whole slew of questions. I actually think Greg did a very good job of responding to most of them about the kind of different buckets of conditions. I mean, I will say, and I think this came through with the way that Greg presented this to the board, is that this is a very complex permit. And as he mentioned, there are, and most of the board members have been at the facility. There are portions of the facility that are covered by the permit because it is a hazardous waste management unit or involved in the treatment of hazardous waste. There are parts of the facility that are completely outside of the jurisdiction of the DTSC permit. And then there's a third group that is they're not directly within the jurisdiction, but they're somehow related to some process. And we were talking about the stormwater tanks issue is that those are not, covered by the RCRA permit, but they're referenced in the permit because they're kind of intertwined with some of the authorized units and the conditions in the permit. So it becomes very, very complex when you try to just put everything into individual buckets. But again, I think Greg did a good job of walking through for the board and talking about the way that he thought about this as he was putting things into various categories in the draft initial order. Hopefully that was helpful.
Yeah, that was, thank you. Any other questions that board members have? I'm cognizant that we have not had any questions on the issues accepted or dismissed for review. Is there anything that a board member would like to raise about that? Okay.
I mean,
Member Brostrom, please.
I think there's, if we're going to move to discussion, I certainly have some issues that I'd like to discuss as a board, but not a question.
Great. So why don't we go ahead and let's move more into kind of the board discussion component, and then go from there. I don't know if Member Brostrom, you want to kick us off.
Yeah, and I did want to, kind of raise some concerns around the dismissal of at least one of the claims. And I wanted to maybe start before I raise that issue is, before I joined the board, when the board was discussing, the rules and regulations that would govern permit appeals, there was quite a lot of dialogue on the concern about unrepresented parties. And, the recognition that a lot of hazardous waste facilities, they're located in environmental justice communities that are under-resourced, and that often, and frankly, that there's not enough legal counsel always to represent all of the communities that may be impacted and want to participate in these proceedings. And I know there was a lot of robust dialogue at the time. And at that time, I was more of a member of the public. And one of my concerns was around kind of a strict exhaustion requirement. And so just to start out by noting, that I think, as we're coming, this is my first appeal. And so it just is stark to me to see the two pro se claimants, that they have failed to exhaust and they're losing a couple of their claims. And I think that's unfortunate. And so more for a broader context, I understand that there are rules and regulations that have been adopted that we are compelled to apply. But I did want to make a note that, the fact that that we are seeing unrepresented parties, failing to properly exhaust remedies and not being able to hear their claims, to me, necessitates maybe more dialogue. And so there's something I want to raise with this board, that we're seeing it in practice. And so I myself would be interested in looking at, whether there are ways to have more flexibility, particularly for unrepresented groups. So that's kind of my big picture. That is something that I wanted to just, say to the board. The other one is in terms of today is, as we are applying our exhaustion requirement, I certainly do think that we need to interpret them as broadly as we can, given the concern that I just stated. And so the one issue that I saw merited discussion among our board was the denial or rejection of the claims regarding the 3 notices of deficiency. And I think that was both 2 of our appellants raised those issues. And the reason why I think that still meets our exhaustion requirements is that, one, exhaustion is about giving DTSC an opportunity to cure and respond. This particular matter, there was no resolution possible. The 3 notices of deficiency were given, well before this proceeding. And ultimately, I see the 3 notices of deficiency as a legal and statutory interpretation. So the issue was request for denial and an incomplete application. And I do think that was properly raised. And the legal argument is that, the statute does require, there's certain statutory interpretation differences at play here on that particular statute that really should, kind of be in the purview, of a legal argument. And so that particular issue to me caused some concern about denying that particular claim.
Thank you very much, Member Brostrom. Anyone else want to comment on that? I can go ahead and jump in. I had a similar set of concerns to what Member Brostrom raised as well with respect to seeing several of the issues being dismissed from the two pro se appellants here. And so similarly, I think the draft mostly does this, and I feel like I've really stress tested a lot of these. I think we should kind of interpret broadly the terms issues and matters here to give these pro se appellants the kind of ability to tie those broad terms to the kind of the words that were raised during the comment process. And so, that's how I looked at this draft. I went back and I looked at very specifically what were the comments that were raised, what was the response, how can we very specifically tie this issue, this matter to what is being challenged here. So that kind of broader perspective is something that I know I brought to this as well. So that's just kind of a general comment. Is there other board discussion that we want to tease out on this issue of the issues that are accepted for review? Okay. Is there other board discussion on the scope of the stay? Anything else that any comments that anyone wants to make?
Chair Rakestraw, not about the stay per se, but we note that the department did ask for additional time, and if you wish, this could be a matter that we handle outside the board vote, or it could be within the purview of today's work.
Thanks very much for raising that. Is there any more board discussion that we have? Would board members like to move to considerations of votes at this point, or take a break to get our thoughts in order? That might be better at this point so that we can, have a more informed voting process. So unless there's any other words, why don't we break? What would be an appropriate amount of time to break? I don't know, Io, Sharma, what do you think? Let's do 15 minutes to be safe. I feel like I always said good. Sheena, why don't you tell us what time we will reconvene?
We will take a 15-minute break and reconvene at 3:10.
Apologies for the long break. That was much longer than we had said it would be. Okay, so where we left off here, Sheena has to clue us back in.
Thank you, Chair Rakestraw. For the record, all members are present and a quorum is reestablished.
Thank you very much, Sheena. Okay, so essentially where we left off when we left is we had, in the middle of board discussion, we had several comments from board members, questions from board members to council. We had kind of a truncated board discussion. And since then, I believe our board council has compiled the comments or compiled the specific changes, or maybe I'll give the floor to Greg to characterize what it is that he has put forward.
Thank you, Chair Rakestraw. So in responding to some of the concerns that I heard during our Q&A session, I've gone back and proposed some line edits to the initial order. These pick up requests the DTSC had around the scheduling, briefing schedule, change that I mentioned in my presentation having to do with setting the date of the public hearing. I think really it's Chair Rakestraw, it was your comments in particular. So if folks don't mind following along with the initial order, I've got the page number there. I've got the lines that are affected by this, right? So Chair Rakestraw, you had a concern about this language, which you see crossed out here. So we're proposing an edit to the initial order as you see here. So that's part one of what we're proposing to edit in the initial order. And this is, of course, in the discussion of the scope of the stay and sort of the justification or rationale, kind of reasoning for the stay and all of that. And then the next edit, if we could, or sorry. Oh, sorry, the board members wanted to highlight this, right? So really not changing much other than removing the language that you're seeing. We're not proposing to add anything. We're just putting a period there. Thanks to Corin for working with me to display these line edits. Okay, and then part two is related, also having to do with the effect of the stay and sort of how we arrived at the interpretation of our reg and the application of that in the initial order. And so we're adding language that I think simplifies this. I hope that this brings it closer to alignment with the discussion and explanation that I offered here in my testimony. So hoping that you all agree with that, or that's another edit that we're proposing, trying to be responsive to concerns you raised, Chair Rakestraw. So those are the language changes as far as the reasoning in the order and how it explains how we arrived at things in the analysis of the state. It goes on for many pages, so there's a lot there. Then the rest of this is just the scheduling stuff. So if you wouldn't mind, I think we're ready to move on. So cross out, we need to line out the 45 days, right? So we're replacing 45 days with 60 days. This is for DTSC's permitting division and Ecobat to file and serve their opposition briefs. They asked for, or at least DTSC asked for more time. So we didn't have a problem with that. I mean, we talked about it at staff level and we think that can be accommodated. And then the last edit here is one that I mentioned, just our request to have more flexibility around setting this date. And we're recognizing that y'all need to know when we're having this hearing. I mean, you could have vacations scheduled and you need to know how to plan for that. So we're not going to string you out forever on rescheduling this date. We're going to make a decision here, finalize this date within 90 days, but we're asking for your authorization to allow the executive officer to do that. This is effectively delegating that task to your executive officer, just so that we don't have to bring this initial order back for another vote before the board. So that's what we're proposing in terms of changes to the initial order. Happy to help in any way I can with that.
Okay, thank you so much, Council Forrest. Okay, so these are the three changes that Greg had presented. Are we ready to take any board action with regards to this or any other? Yeah, actually, yeah, I think now would be an appropriate time. If please, you can approach the podium.
I would have raised this during my comments, but I assumed there would be motion. The appropriate vehicle would have been a motion. So we would like to think about this briefing schedule in two ways. First, similar to the point that DTSC made, we'll get two complicated oppositions. 30 days is a pretty quick turnaround on a brief, and so we would like to request 45 days. But I don't know how that's going to fall in terms of the calendar. So I'm not able right now to verify with our team how this works. So we would like to request for now 45 days instead of 30 for our reply brief, and just have some flexibility to get back to you like tomorrow in case I get back to the office. I don't have my calendar on my phone. So just to get back to the office and check in with the rest of the team. So if we were to ask for any changes, they would be very minor, recognizing the schedule you're trying to put forward here.
Thank you very much, Council. Does the staff have any initial response to the request to? Okay, great. Okay, perfect. Yeah, so just to reiterate the briefing schedule changes. So opposition, so DTSC's permitting division, that would be 60 days here. Then reply briefs would be due 45 days after opposition briefs are filed, if I understand the correct. I see nodding. Okay, so I think that's the current, and we can kind of, amend that text accordingly. Any other issues that board members would like to place on the table before we move to consideration of various motions? Yep, please go ahead.
Thank you. So just in the interest of making this absolutely clear, in the initial order, we have also, in addition to the reply brief, which we're saying is 45 days, totally fine with us, we have a separate deadline for filing an amicus brief, and that's established in our schedule, or in our standing order. It's 30 days. I don't think we're talking about changing. The request we got was just for the reply brief. So I think we just, in the interest of clarity, want to make sure that we're all on the same page to know that we're not changing the amicus brief filing date. That would still be 30 days. Okay?
Okay, thanks so much for that clarification. Seeing no other requests for the floor from board members, do we have any motions that board members would like to put on the table here based on the discussion so far?
Chair Rakestraw, why don't I get the ball rolling? I move that we accept the staff recommendation with the changes that have just been put on the screen before us and the participants.
Thank you very much, Vice Chair. Is there a second?
Second.
A second. So we have a motion from the Vice Chair to accept the staff recommendation with the amendments that had been displayed on the screen from our board council, and we had a second from member Williams. Is there any further discussion of the motion that's on the table here? Member Brostrom, please.
Yeah, thank you. I came in, with two main concerns. One was this concern about, being very clear about separating out capital, expenditures, and kind of more practice oriented in this day. I think that was adequately addressed for me, by our council, by the Ecobat's council. The other concern that I had was, in my opinion, what was an overly narrow interpretation of our exhaustion requirements, particularly because of how many, pro se claimants we should anticipate in front of us. Not only concerned for today, but also, future precedent. I understand that we did not make amendments to capture those concerns, and so I'm not going to be able to support this based on that narrow issue.
Okay, thank you very much, Member Ostrom. Did you have any amendments that you wanted to make to the motion, or was it just a statement for the record?
It was more of a statement for the record, and I did want to still encourage our board to revisit this issue outside of an appeal process, so that we can really dive in a little deeper on how we can make sure that pro se and unrepresented claimants can participate with as few barriers as possible.
Thank you very much. I mean, if I can respond to on this particular issue, I mean, again, as I expressed earlier, I share the general concern, but I do have to say this on the Chandler Appeal issue 17. I guess my perspective is it's the wrong issue to draw the line on. I spent the whole, much of the break reading through this issue and just trying to find ways to see if we could accept it. And in looking at the comments as kind of broad and liberally as possible. And my view, I feel like I couldn't at least get there. There was no language hooks to make that argument. I understand your perspective, but my perspective is this is not the right issue to draw that line on, even if the broader concern still exists. Okay. Any other comments from board members? We have a motion. We have a second. We've had some bit of discussion on that. Hearing none. Sheena, will you go ahead and please call roll?
Thank you, Chair Rakestraw. Member Atkins,
Aye.
Member Brostrom,
Abstain.
Chair Rakestraw,
Aye.
Vice Chair Strauss-Hacker,
Aye.
Member Williams. That motion passes with 4 ayes and 1 abstention. Chair Rakestraw.
Thank you, Sheena. And thank you again to our technical team for their presentation, for the enormous amount of work that they did. I hope for those who are unsatisfied with the outcome that at least you can have the confidence that our team is spending the time and effort needed to go through the details. And that has been a constant drumbeat, at least from me as board chair, pushing the team to really dive into the details as much as possible, both on these issues as well as the scope of the stay. That said, there is an enormous amount of work before us here on this appeal. There are many very substantive issues that have been accepted by this board. And I think as we heard, at least, my perspective, and I think this was, this is confirmed by council, is that all of these issues that have been accepted are on the table and are kind of without prejudice to this board's ability to provide relief. And so I at least look forward to receiving those written briefs over the next several months and encourage us to schedule the hearing as soon as practicable, recognizing the broad interest in this hearing. So again, thank you all for coming here today, spending your day with us, providing us with your public comments, and we will certainly be in touch. Okay, so that concludes agenda item number 3. So we now have agenda item number 4, which is the executive officer report and board member reports. We're running behind schedule, and I am cognizant that we also skipped through the time that we had allocated for public forum. So we will put public forum at a kind of, we'll figure out a time that we'll have it tomorrow, and we will announce that by the end of this meeting so that folks can know at what time they should join to raise issues that are not on the schedule.
I just wanted to check in with the clerk if we do have folks lined up for public forum. No, there's no, okay.
We haven't called for that item yet, so nothing as of right now.
Chair Rakestraw, just a point of order. If we could take a 1-minute break, it would allow people to leave.
Yes, that's a great idea. We'll take a 60-second break.
Thank you, Chair Rakestraw. As quorum is established with all members present. Thank you.
So in the interest of time, we are going to do a truncated version of the EO report. And so I do not think we're going to get to a few of the items in the EO report. If there's time tomorrow, we will continue this agenda item. Okay, next slide, please. So we'll give you all an update about the 2026 as well as tentative 2027 board meeting dates. permit appeal updates, BES contracts, a board recusal presentation from our board counsel, Greg Forrest. If we have time, we will review action item follow-ups and board updates, but likely E and F will be moved to tomorrow. Okay, board meeting schedule. Next slide, please. We have the following 4 dates. December 14th is the newest date added to our calendar. So July will be in Sacramento. August will likely also be in Sacramento. October will be back in LA, likely in Montebello. And then December will likely be up in Sacramento again. Next slide. These are our 2027 dates, but as we just discussed, our January 27th, 28th meeting may move so that we can find a facility big enough to hold our appeal hearing. So stay tuned on our website as well as these meetings for the most updated board meeting schedule. Okay, next slide, please. The board does have 2 pending appeals, one from FiberTech permit renewal. There are 2 appeals filed. The board did receive a stipulation, and there was a settlement of PTI's issues 4 and 5 on that stipulation. You can find the materials related to that settlement and stipulation for 2 of those issues on our BES website. And as you heard today, we also have an Ecobat permit renewal, multiple appeals filed for this. The full docket, again, is on our website. Next slide, please. In front of the board today, we do have 2 contracts. These are existing contracts that we are seeking a new or renewal contract. One, the board staff is seeking an approval by the board for public meeting logistics and coordination services contract with University Enterprises that's affiliated with Cal State University, Sacramento for coordination services. So they are the ones that help put on our board meetings. They coordinate, they facilitate, they help with the logistics end of our board meetings. The contract amount is for $300,000, and the contract would set to expire on June 30th, 2029. Your board packet materials have more details about that contract. And then the second contract is for, next slide, please, interpretation contract. So this is for Cal Interpretation. They're the ones that provide the Spanish as well as multiple language interpretation. They're the ones that also translate all of our board packet material. And that is for an amount of $75,000, and that contract is set to expire June 30th, 2029. So I will pause there and turn it over to our clerk for the contract. If there's any questions from the board about either of those contracts and for a possible vote.
Okay. Are there any boards? So right now, the issue that's in front of the board are these 2 contracts that our executive officer just spoke to. Are there any board member questions with respect to these 2 contracts?
Chair Rakestraw, not a question, but just a comment for benefit of all. As you can imagine, the board doesn't have its own facility, its own equipment and the like, and therefore the virtue of having had these services, these contractual services, since largely the early days of our inception, have allowed us to continue to hold hybrid public meetings where a great deal of public participation occurs both in person and online, and we very much appreciate that. So I would, at the appropriate time, like to make a motion in support of these 2 contracts.
Thank you very much. Now might be the appropriate time, seeing no other requests.
Chair Rakestraw, I move that we approve the executive officer's authority to enter into these contracts.
Thank you very much. We have a motion to approve or to provide the executive officer with authority to enter into these contracts. And we from Vice Chair Strauss Hacker, we have a second from Member Atkins. Sheena, will you please go ahead and call a vote?
Thank you, Chair Rakestraw. All those in favor, please say aye.
Aye.
Any opposed? Any abstentions? That motion passes unanimously. Thank you, Chair Rickstraw.
Thank you. Now I'll turn it over to our board counsel, Greg Forrest, to do a presentation about board member recusal.
Recusal. Sorry, I'll just start over. Thank you, Swathi. I'm presenting today regarding some key concepts that apply to our permit appeals process, particularly related to board member recusals. I want to start by distinguishing between different functions of our board. I think these fall into two broad categories. The first category are quasi-legislative functions that include policy-making endeavors like the Hazardous Waste Management Plan, DTSC fee rate setting, program performance metrics, and the DTSC evaluation, and others. In that setting, which is most of what we do, the board sets broad policy applicable to entire categories of stakeholders such as fee payers. The other main category of board functions are quasi-judicial functions, where the board makes decisions affecting only one facility at a time rather than entire categories of facilities. These are our permit appeals, and there are different procedural standards that apply to those decisions. So I'm going to be focusing on those today. Because of the nature of permit appeals as a quasi-judicial function of the board, constitutional due process requirements apply to the appeals process. The board makes a facility-specific decision at a public hearing. Under the Constitution, a fair hearing requires a neutral decision maker. It may be helpful to think of your role as a board member in a permit appeal as being similar to serving as the member of a jury. We're all familiar with jury selection from movies or possibly our own experiences serving on a jury. People who serve on juries are told to avoid having side conversations with the individuals in the case. Jury members are expected to have an open mind and avoid displaying any bias or prejudice. Similar to jury service, ex parte communications are prohibited during the permit appeals process. The parties to the appeal must not have private conversations with board members. That strict prohibition applies to you, the decision makers. As staff members, we also avoid ex parte communications as a general practice, but we also need to field questions from the appellants to an appeal. So the parties may ask procedural questions of board staff, but board staff cannot provide legal advice. We have developed a set of frequently asked questions on our website that we maintain, and we also have other resources to help assist individuals to understand the appeals process, but we don't have a helpline, so to speak. Next, I want to cover one of the biggest questions that I get, which is abstaining versus recusing. Abstaining from a vote is when a board member participates in an item at a board meeting, but refrains from casting a yes or no vote. This is a voluntary decision left up to the individual board member and may occur for many different reasons. An obvious example is when a board member was absent from a meeting and abstains from the vote to adopt minutes. A board member may also abstain for other practical or personal reasons, such as recovery from an illness or returning from a leave of absence. Recusal is different because in a recusal, the board member takes no part in the appeal, leaves the room, and is not present for any of the proceedings. Unlike an abstention, a recusal is a mandatory requirement that is based on the due process requirements that guarantee a fair hearing. An example where a recusal is required is where a board member has a conflict of interest. As an additional procedural safeguard to ensure fairness in the permit appeals process, we require separate functions between the participants, the appellants, DTSC's permitting division, facility representatives, and then board staff. Using myself as an example, I am the attorney advisor for the board. It would be improper for me to also serve as the advocate for DTSC's permitting division. So we have separate attorneys that serve in that capacity, and we maintain an ethical screen that reinforces these separate functions. Along with the separate functions, we have other practices that help ensure fairness in the appeal process. We require service of process, which is just a fancy way of saying that all of the parties are copied on all the correspondence during the appeal. We maintain transparency and accessibility by actively updating our appeals docket on the board's website. In addition to public board meetings, virtual meetings and conference calls also occur during the appeal process. Parties are encouraged to settle differences and may meet and confer to try to reach agreement on matters in dispute. Those are arranged by the appeal parties themselves. Board staff also hosts status conferences that include all the parties to the appeal. We record those, so we maintain transparency. All right. Last slide that I have is about the decision-making process for permit appeals. You can think of this like a pyramid where the full board sits at the top and makes the major decisions, including the initial order and deciding the merits of the appeal after a public hearing. Because we are only required to have 6 board meetings per year, we do need the ability to decide procedural questions that arise, particularly regarding the administrative record. Our standing order delegates those procedural decisions to the board chair and vice chair. At the bottom level of the pyramid are the board staff. We do the grunt work on the appeals, which come to you in the form of recommendations to the full board. In the past, we had a very small staff, and we used a subcommittee of 2 board members to formulate those recommendations, but that is no longer the case. We also answer questions from the public, but as I mentioned earlier, we do not provide advice to the public. We do, of course, give advice to board members. Before I turn this back to Swati, I just want to say that the hearing appeals is something that we take quite seriously and involves a lot of hard work by literally everyone on our staff. So I want to recognize all the board staff and the many hours of work that goes into ensuring that our permit appeals uphold the highest standards of integrity. I hope you all feel very supported as you approach this work, and I hope you all view this with the same pride that we do. That concludes my presentation.
Thank you, Greg. Do board members have any questions for Greg on his presentation before we move to the next? All right, next up, we will have our ombuds, Lauren Chandler, who will be joining us online to give an update on the board action items.
Good afternoon. A total of 14 action items were recorded during the public meetings held on April 27th and 28th in Montebello. Next slide. We'll start with the 12 items for DTSC. Next slide. Member Brostrom asked for DTSC slides about the hazardous waste management plan that were presented at the CUPA conference that took place March 23rd through 26th in San Diego. The slides were shared with BES on May 7th, and DTSC has presented similar content at their workshops. They will also be presenting to the board tomorrow, and their presentation is available on the BES website, so this item is complete. Next slide. Senator Atkins requested more information about how DTSC tracks dry cleaners in California. DTSC estimates that there have been approximately 15,000 to 17,000 dry cleaners in California, but no single comprehensive statewide list exists. Using the hazardous waste tracking system, DTSC's Discovery and Enforcement Program identified 7,495 potential dry cleaner sites, of which 184 high priority sites were selected based on CalEnvirScreen scores and proximity to sensitive receptors. Across all DTSC programs, approximately 470 dry cleaner sites are currently active or closed, and about 970 dry cleaner sites appear in EnviroStore. DTSC and partner agencies are interested in developing a statewide strategy for addressing legacy dry cleaner contamination, including options such as a fee-based cleanup program or dedicated annual funding, as current polluter pays and orphan site funds are insufficient. DTSC is happy to meet with Senator Atkins to discuss further, but this item is logged as complete. Next slide. Chair Ragstra asked for more information from DTSC about their tribal outreach efforts in order to get the board more involved. The department will include BES in future outreach to our Native communities, so this item is currently in progress. Next slide. Chair Rakestraw asked for DTSC's takeaways or themes being noted as source reduction reports are being reviewed. While this item was partially addressed in the recent hazardous waste management plan, it is logged as ongoing as DTSC staff continues to review the reports. Next slide. Senator Atkins requested an invite to tour Solar Turbines Inc. in San Diego with the DTSC permitting team and BES's tech team. Plans for a tour are still in development, but a date has not yet been set, so this item is in progress. Next slide. Member Brostrom asked DTSC's Wayne Lorenzen how many public comments were received during the comment period that ended on March 17th for the Clean Harbors Buttonwillow permit renewal. A total of 8 were received, and this item is complete. Next slide. Member Brostrom requested a report on the types of vapor being found under the Exide site and in residences near the site. DTSC responded that the soil vapor plume at the Exide Vernon facility is confined to the immediate area around the site and does not extend beneath nearby residential properties. Elevated TCE levels in soil and soil vapor are limited to the south yard, tied to historic operations in the former mixed metals extrusion building, while PCE and other VOCs are present at lower concentrations. The Vernon Environmental Response Trust, in coordination with DTSC and EPA, is currently conducting a soil vapor extraction pilot test in the south yard to evaluate the effectiveness of this cleanup method, with DTSC receiving monthly progress reports. This item is logged as complete. Next slide. In reference to the Exide site, Senator Atkins asked about best practices when it comes to curbs, gutters, and streets near the cleanup, and whether any sampling of the roadway is taking place. Per the Director's Office, because paved surfaces do not accumulate or retain lead like soil does and act as protective barriers, they are generally not sampled. Sampling instead focuses on exposed soil areas where children or residents may come into direct contact, while routine stormwater and street sweeping programs help prevent lead from lingering on hard surfaces. This information was relayed to Senator Atkins, and this item is considered complete. Next slide. Member Brostrom asked about any funding or resources that DTSC will need to potentially expand the cleanup at Exide. DTSC responded with information about potential contamination up to 1.7 miles from the facility and has established a preliminary investigation area, or PIA, with a radius of 1.7 miles. DTSC is currently focused on the properties within the PIA and will continue to commit available funds to complete the work. This item is logged as complete. Next slide. Chair Rakestraw requested additional information about how DTSC intends to implement the hazardous waste management plan, specifically what activities DTSC will do in the upcoming 26-27 fiscal year. DTSC is currently in discussion with BES to determine which of their activities they should present to the board during an upcoming public meeting, so this item is still in progress. Next slide. Chair Rakestraw requested information about DTSC's plans for the public participation manual moving forward. The Director's Office will be providing an update during day 2 of our meeting tomorrow, so for now we are still in progress. Stay tuned for the update. Is there any additional information needed or any follow-up questions so far?
No, you can continue.
Okay. Okay, next slide. We're going to move on to the one action item for BES from April. Next slide. Member Brostrom has requested further collaboration with DTSC to implement and institutionalize the hazardous waste management plan and deliverable tracking. This item is currently ongoing as BES and DTSC work to develop a plan together. Next slide. There was also a request from a member of the public at our last meeting. Next slide. A member of Parents Against Santa Susana Field Lab notified the ombuds, myself, that they had not yet been assigned a new department liaison. The Director's Office notified us that the new DTSC liaison for SSFL is Rico Jones Modeste, and they have already been in touch. Next slide. For information about the board, the Ombuds program, or upcoming BES meetings, please visit our website at www.bes.dtsc.ca.gov. Thank you for your attention.
All right, just one minor update on the solar turbine tour that was scheduled but had to be rescheduled. So it's in the works to being rescheduled. But I know that the DTSC team did work on scheduling that. So I just wanted to acknowledge the team. That is it. I don't believe we have enough time to get through the board updates. So I think we will table that and then open it up for public comment or board questions or discussion.
Well, first let's do, I guess, yeah, let's do public comment. And then if there are any board member questions or comments after that, we can take those. So Sheena, will you please open it up for public comment on the EO report?
Thank you, Chair Rakestraw. The floor is now open for public comment for agenda item number 4, the Executive Officer Report. So for those in person, please raise your hands if you would like to comment on this item. And I will call on you to approach the podium. You have 3 minutes.
Thank you. My name is Jenny Knack, Parents Against SSFL. I'm sure this is just an oversight. I haven't been contacted from the new communication specialist. I just checked with Melissa Bumstead. The other co-director, she says she has not either. So, but now that I have that person's name, I will find a way to contact them. So we'll work it out. And I guess I have a question. I know this isn't a back and forth, but I did understand that a decision had been made on the administrative record by 2 people on the board. What I did not understand was that that is how decisions on the administrative record are made. And as that is the basis of substance of what is going to be looked at for any permit appeals, I think it's problematic that 2 people on the board, outside of any full board discussion or public, like that decision is made in a way that I think limits the point of achieving what an appeal is hoped to achieve. And my question, I guess, is that decision-making procedure okayed by the legislature? Is that something that's very transparent? Does everyone know that that's how that process proceeds? Because from my perspective, just watching this go down, I'm like, well, that isn't going to work in an appellant's favor, probably ever. And is there a way to change that? Is this a process that can be amended? Because it seems skewed from the outset. We haven't even gotten to the hearing, and it's already been limited in a very untransparent way. And Greg just, said that sorry, I'm kind of upset about it actually, because we're relying on the entire board to make decisions, allowing people to interact with the agency. And this seems like an incredibly unfair loophole. And I'm used to dealing with loopholes with DTSC, but I'm not used to dealing with loopholes with the board. And I'm wondering, and it isn't anything personal about who made the decisions. But is that something that's changeable? Does anyone else on the board or otherwise see that this is a potential problem? I could go on for the rest of my time, but I won't.
Thank you. Are there any additional in-person comments? Seeing no other hands raised in person, those of you on Zoom, if you would like to comment on this agenda item, please raise your virtual hands. Seeing one so far, Ivana, I'm going to send you a request to unmute. You may go ahead.
Thank you. Hi, this is Ivana Castellanos with Physicians for Social Responsibility, Los Angeles. Thanks for the presentation regarding recusals and abstention. I think this is an important conversation for the board to hold with the public, and but I think the presentation misses a discussion on defining what actually constitutes or might constitute a potential conflict of interest, not only in permit appeals, but also in other aspects of the board's work. And it also misses processes for reporting and evaluating potential or perceived conflicts that are transparent and engage the public. Thank you.
Thank you for your comment. Are there any additional comments on Zoom? Seeing no more hands raised, Spanish interpreters, please let me know if there are any comments in the Spanish room. No comments in the Spanish room, Chair Rickshaw. That concludes this public comment period.
Thank you very much. And I can briefly address the comment, Jenny, that you had raised here. So in respect to your question of can this be changed? Yes, it can. It's in our standing order where in the first paragraph here, it says motions are decided by the board chair and vice chair in accordance with the rules set forth in this order. And then there's a process for receiving motions later in the standing order. So that's what we were working off of. Is the delegation to the board chair and vice chair, specifically to decide motions. And as Greg explained, the rationale is that it can be done quicker, in particular if there are motions for requests for additional time and so on. But of course, the motions on the administrative record also fall within that category as well. So that's the process, that's the rationale, and in theory, this board could change that should it want as well, because it's through our standing order, it's not through the regulation itself. So hopefully that answers your question on that.
Can I just add, so for the changing the regs, we have to go through a whole emergency reg process. It's doable too. It just takes more. It's more of a process. Standing orders is something that comes to the board as a vote. So we've already changed it a couple of times. So it is something that's doable to change.
I note that the board staff goes to great pains to post materials on our website quite quickly. And so I think that the intent of transparency is being met, not only in looking at many of the motions of this ilk, you see a very, very long list of parties copied who are parties to the matter in some way, but it's also made available to the public. So that's one piece, the transparency piece, I believe. The other piece that both our executive officer and attorney had mentioned earlier is when the board meets just 6 times a year and has a frightfully difficult time getting even a venue like this that wasn't big enough, it would put off until a full meeting of the board prospectively for like maybe 3 months, hearing a simple matter about whether this document or that document might be something that DTSC relied upon. And so we were thinking in doing this, and you should look at the standing order, that this would help bring more timeliness to hearing permit appeals in a public way.
Thank you very much, Vice Chair. And then actually, I would like to add to kind of like the action items, the comment from Ivana with respect to the recusals and conflict of interest. I know that, Greg, there's a whole array of standards for conflicts of interest. I think maybe one thing that could be useful if you could kind of send that to Ivana, because I know you've certainly showed that to me as well for transparency purposes. Okay, so that completes the executive officer report here as well. It's now 4:30. Why don't we go ahead? Okay, so why don't we go ahead and do the last item on our agenda right now, which is the review, discussion, and possible approval of the minutes. I think it's going to be quite brief. We'll then do closing remarks. The one item we did not get to today because of the length of the initial order was public forum. Why don't we go ahead and move that to the first item tomorrow so we can open with public forum. There's a time certain for those that wish to raise items that are not otherwise on the agenda. I think we can communicate that out. So let's go
And
ahead.
board updates, that's the only other item we didn't get to. We can do that tomorrow too.
Great. Okay, well, why don't we go ahead and do this last item here on the minutes. Board members, you have in your packets the minutes from our April 27th and 28th, 2026 board meeting. Is there any discussion regarding these minutes? If not, can I have a motion to approve these minutes?
Chair Rakestraw, I move that we approve the board meeting minutes for April 27th and April 28th.
Is there a second?
Second.
Motion to approve these minutes, and we have from Vice Chair Strauss Hacker. We have a second from Member Williams. Gina, will you please call the roll?
Thank you, Chair Rakestraw. All those in favor, please say aye.
Aye.
Any opposed? Any abstentions? That motion passes unanimously. Chair Rakestraw.
Thank you so much. I think we'll go ahead and use this moment to conclude today's meeting because we do have a very hard 5 o'clock cutoff and they'll lock us all in here. I think we spent a lot of time together. I think this evening a little bit of a break would be good. But thank you all. I don't feel like I have anything to add. In terms of closing remarks, I won't try to summarize today's discussion, but just to thank you all for the time, effort, and attention to detail, particularly the fellow board members here, our board staff, and you all. So with that, do I need to have a motion, Sheena, to adjourn today?
No, Chair Rakestraw. If that concludes it, thank you, everyone. Today's meeting is officially closed at 4:30 p.m.